Yes. Who are you here on?
Sal Plata.
Mr. Plata, can you come forward, please?
Marvin. Judge,
Yes.
this one's set for plea today.
Okay.
I was hoping for one more to finalize some immigration issues that we have with this case. I think he's trying to purchase some property in the US too. We can look at that and the immigration consequences it might have on that. I think this is going to the trial docket. We also need to hoping for a little more time for the trial fee as well. So I'm
Okay,
hoping for-
please set it for trial in February 2025. That will be 1 year from the date of the alleged offense. All right,
Thank you, Judge.
that gives you 2-3 months. That seems like a pretty good
We'll do
deal.
what we can.
You okay?
We'll do what we can.
Okay,
Thank you.
is
But we need to work on the trial fee and set payment plan for that. So I don't know at this time if we're able to
okay.
do that.
Well, let's set it then for our next criminal docket day, and you'll have another plea setting on that day.
Thank you, Judge. I appreciate it. Thank you. Thank you.
I would think 90 days would have been a better deal. Hey, how you doing, Tommy? Good to see you.
Great, Your Honor. How are you?
Good. Do you have the motion for me to review?
Only digitally. It's with the,
Do you have a computer that I can look at?
I
or
do,
something?
I can do that.
Your client is,
She's present.
Name?
Blunt, Blunt,
Kim
first name
Blunt.
Kim, on the jury announcement document.
can you come forward, Ms. Blunt? How you doing today?
I just got out of the hospital, had another heart attack.
Sorry to hear that. Well, we need to come to some resolution in this case. So you're continually not coming here and we can start getting you help. Are you on pretrial services?
What's that?
That would answer my question. It's just people that Hayes County has set up to help you in the meantime. But
We can talk.
Okay. Yeah, I want a solution too.
I'm sorry?
I want a solution too.
Yeah, no, I'm sure. Do you have all the discovery in this?
We have a lot of discovery, Your Honor. That's the main basis for our motion. Only way I can think to describe it is it's similar to a white collar case in the sense that
I don't see anything in your motion regarding not having discovery. Is that? All I see is that there's.
No, it's not that we don't have it. I said there's a lot of,
Oh, okay.
your average, I mean, if you just look at the offense, state jail, it's more like a white collar in the sense that, the discovery is, the stack is this tall instead of this tall, which is a lot of documents and, as well as media. In other words, there's no outstanding discovery that I don't have any reason to believe we're missing anything.
So what do you suggest, counsel? I'm sitting here looking at someone who is continually having a tough time every time she comes in front of me. Just had another heart attack. We continue to make her come back to court. This case needs to be resolved. There's an opportunity for it to be resolved, and you say no. And I got to look after her interest. And how many other times have we had a trial setting?
This is our first trial setting. Ms. Blunt did have a previous counsel. We subbed in May, I believe. And so I know this is our first trial setting since we've been on the case.
And you're not able to try it? You and your co-counsel?
Oh, we're more than capable of trying it. It's just the time to getting through all the discovery to get up to speed.
When were y'all appointed to it?
We were retained, I believe, in May.
Oh, you were retained?
Yes, Your Honor. That sound about right, Kim?
Mhm.
Around Memorial Day?
Seven months? You don't have,
Well, it's not the only, obviously, it's not the only case we're prepping for trial. In fact, we have a big one coming up in your court in mid-December that's been the focus of our firm's attention for the last couple weeks.
And Judge, I do have a motion regarding that other case.
when was the last time you were tested?
Then you tested me last month or the last time we were here.
And were you clean?
Yes, I was.
And will you be clean today?
I should be, yeah.
All right, let's get a test. I'm going to sign up pretrial services to Ms. Blunt, please. You'll take that over. All right, let's get that.
Can we step
done.
away?
Yes.
Okay. So,
Here you go. Tommy, take your computer.
yes, sir.
Thank you.
Judge, did you want to handle that motion on the other off
Sure,
docket
while we're
matter real
here.
quick? State has a motion to dismiss. And I'd be happy to give the court additional information, but I would ask that we do it off of live stream.
I mean, I see what you write.
Okay,
I trust you. You learned
so
it.
we can't prove it beyond a reasonable doubt at this point in time. Cassidy, talk to Haley.
Case dismissed. Let your client know.
I will.
Li Jingwei, is that the only thing he's being held on?
I believe as of today it is.
Let him out of jail. There you go. Let's
Thank
figure
you,
out
Your
this Blunt thing.
Yes, sir.
All right,
He does have an ice hold, so
Yes.
he will go to.
Yeah.
But let me know if you have.
but
any
get him out
questions.
of Hayes County Jail. Hello, how are you?
Judge, how are you?
Good, who are you here on?
Hi, here, Mr. Nitch, Cole Nitch.
I said nut. Was I mispronouncing that?
Niche, N-I-D-S.
All right, sorry about that.
But I wasn't dispensing it.
Oh, niche. I'm sorry. Nuth is right after that.
Uh-huh.
Pardon me, Cole. All right. Do you have discovery in this case?
We do, Your Honor. This is our first appearance and we just got the offer from the state.
And do you have an offer too?
Yes,
Very good. Anything you need from the court?
not right now, Your Honor.
Anything-
It's a reset.
Anything from the state?
Yep.
State, anything you need?
No, Your Honor.
All right, the regular pretrial setting. Reset.
you.
Thank you.
Thank you.
Have a good day. Yep. All right, you want to approach on Tucker?
Yes, sir.
Come on up, Tucker, Cade Tucker. All right, both sides announced ready for trial on December 2nd.
Yes, Your Honor.
All right, anything else we need to take up? Do you have an offer?
There was a,
You don't have to tell me what it is. I just need to know if you have an offer. In order for him to waive his rights, I believe he has to have full knowledge of what his offer is. Do you have an offer?
no, we don't.
State has made an offer, Judge.
Okay,
What is it?
well, we're not gonna do that in front of me. You two step back and discuss the offer. Thank you.
Thank you, Judge.
How you doing, Mr. Jones?
I'm the jury office.
Yes.
He has a vacation letter on file for today. He was saying he didn't get notice to me. I contacted him. He emailed. His client's not here. Do you want him to just appear on December 2nd?
Yes, he sent us a,
I'm
To
trying
you
to
and the
get
client?
an announcement.
what's that?
Trying to get his announcement.
Quiet, please.
Struggle.
Okay,
So she has no idea what's going on. She's arguing with staff on it.
okay.
So,
So I just put it in an email and we include the state.
okay, but they
Okay.
just need to be here.
Yeah,
Are
they
you
need to be
okay
here.
if the Mr. Marmolejo doesn't appear today?
It's okay that he does not appear today.
John Hindera is saying that he didn't know to be here. And he's on vacation.
Okay.
He'll be here December 2nd.
Okay, so we're back to the question, does the defendant, come on up, Mr. Tucker. Does the defense have an offer?
Yes, Your Honor.
Very good. And you have all the discovery that you need?
Yes, Your Honor.
All right. Anything else we need to take up before trial?
One issue is, I've got my expert, Dr. Thorne, who's sort of equivocating. He said he's set for 4 other trials. He says he will be as flexible as possible. I said I would expect to call him December 2nd or December 5th. He hasn't given me a flat yes or no. We'll have to address that as the trial progresses. But I wanted to inquire as to whether the state, in the event that Dr. Thorne's availability is limited, if he could testify via Zoom. But that's something that we can discuss, I suspect, on the 2nd, when I know more clearly about what his availability is. As I said, he won't give me a clear yes or no, just that he has other cases that are set.
And Judge, the state's not going to have any objection to testifying via Zoom. That's not a position that we can really take. We don't have a right to confront witnesses, only the defendant does. So it's at the discretion of the court.
Very well. Okay, well then let's be here on December 2nd for trial. I'll qualify the jury and then come back and after I've qualified them, we'll know which case it is and can move forward. You're welcome to be in touch with the coordinator and ask what happens to that case in front of you. By the code, I'm required to try a jail case first. After that, the oldest case would be this one.
Yes, Your Honor.
And the state may know further about that jail case and what the status of it is. Just from the coordinator, seems to think that it's going to be resolved, but I don't. State would know that better than I would, or the defense attorney who I haven't seen yet today. All right.
Yes, Your Honor.
All right.
Thank you.
Yeah,
No
thank you. We'll
excuse.
see. You may. Yes.
Good morning.
Good morning.
Miss Copeland is on your docket. First one we'd like to pick up is Miss Copeland on your docket. Evelyn Copeland, see,
Copeland.
we are conferring. We
Ms.
have-
Copeland, can you come on up real quick? Let her know. We're looking at her case. Good morning, ma'am. All right, we're just here on a pre-trial setting on your case. Defense, do you have discovery?
It's ongoing, yes, sir.
Okay. And you have an offer.
Not yet. We're still conferring with the state. There's a companion civil suit that's involved. The state would like to reach out to a claim witness to get some more information.
Okay.
Before
State,
we-
when do you think you can get that
Uh,
reached out and get an offer to them?
Judge, we're in the process of figuring out who in our office is assisting us with these types of cases at this point in time, since the person who was doing it just promoted. So it may take us a week or two.
And I can tell you the claim witness has been a little slow to respond in the civil suit. It's in the settlement process. So I cannot say that the complaint witness is necessarily quick to respond to such inquiry. But it is ongoing.
Let's please set it for the December criminal docket. And I hope that that time state, you'll be able to let us know who is assigned to this case. All right,
Yes, Judge.
anything else that we need to take on?
Not with this case. Your
All right, after you get your reset, you're free to go about your business. Thank you.
In other cases, Mr. Michalowicz, I have read through, he has undergone his site, just to back up to bring you up to speed. Already been sentenced. He was to do an evaluation at the last setting, which was a formal sentencing.
Yes,
We set this for a status to see where we were with that.
I'm just, let me catch up.
Mhm.
I know you know it way better
Yes,
than
sir.
I do. We came here and we were going to do.
We had a contested motion to
Contested,
adjudicate
okay. And you put on
the
the
DWI.
DWI.
Correct.
You found it true.
Yes,
You adjudicated him and sentenced him to probation, but you wanted a psychosexual evaluation completed before you determined additional conditions that you might deem appropriate.
yes.
Oh,
You'll remember him when he comes up.
no, I remember him.
Oh,
I've seen him.
yes.
But I'm saying, I was just, I didn't know that we got through the punishment. But
Oh,
I kind of remember now, he was,
Yeah,
it was like 2 days after the
and
plea agreement, a week after the plea
yeah,
agreement.
it's short in time.
Yeah.
But maybe not
Fair
that
enough.
quick.
He got this, then he did very well and went to his own.
Yes,
On
has
the system.
undergone a lot of
So-
residential and
That's right.
intensive and continues in a sober living.
Okay,
That's it now.
sounds great. So all we need to do is come in here and do the impose the conditions that are,
We
okay.
finalize particular conditions.
Have y'all talked that out and can we do it?
So the recommendation
Let's get
is,
Mr. Michalowicz up here. Come on up, Mr. Michalowicz, so he hears what's going on.
I think the judge did a lot of the standard conditions. This is just some very fine tuning
Okay.
in relation to any kind of.
How you doing, sir? Good. So you were saying,
so the therapist has recommended that he continue with his substance abuse treatment and then mental health counseling and individual counseling regarding healthy sexual behavior. It's sort of a modified curriculum from the sex offender therapy.
okay. Do you understand those new requests that have been made?
No.
I have not discussed those
Oh,
with him,
okay.
Judge, because we're just going off the record, just a paragraph of
Okay.
the recommendations of the
Well-
report. So
Why don't y'all talk about what they are?
Okay.
And
Yes, sir.
if you accept them, then I'm inclined to follow the recommendation of
Absolutely.
probation.
we'll discuss them in there.
Okay, let me know when you're ready.
Thank you, Judge.
Thank you. Hello, Mr. Jones.
Good morning, Aaron.
How are you?
I'm all right.
Good to see you.
On your regular docket,
Yes, sir.
I have Mr. Ariola, the clerk has paperwork right there. He's up.
Areola,
Ariola, all right.
spelled exactly like you think it is.
We're gonna send this today.
Yes, Your Honor.
Very good. Ruby, are you ready?
Yes.
Court calls CR 23-4526F, the state of Texas versus Samuel Ariola. Can council please make their announcements for the record?
Allison Booth for the state.
Richard Jones for the defense.
And are you the same Samuel Ariola who in CR 23-4526F is charged with theft 2,500 to 30,000? Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, I have paperwork here that indicates you would like to enter into a plea bargain agreement. I'm showing you what's labeled the court's written admonishments, this waiver of rights and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, Your Honor.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, Your Honor.
On page 6, is this your signature?
Yes, Your Honor.
On page 5, I'm sorry, let me go back a page. There's some stipulations. Yes, I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes, sir.
And you went through this full document with your attorney?
Yes, Your Honor.
All right, sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow the agreement, I'll allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, sir.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial, and you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, Your Honor.
Understanding those rights, you wish to proceed with this plea agreement?
I wish to proceed.
And are you a citizen of the United States?
Yes, sir, I am.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence pursuant to Article 3914. Are you satisfied the state fulfilled that obligation?
Yes, Your Honor.
And do you believe that Mr. Ariola is competent to enter into this plea today?
Yes, Your Honor.
The reason we talk about the evidence, because you have the right to know what the evidence is against you. Did you discuss that with your attorney?
Yes, sir.
And are you satisfied that your attorney provided you with effective assistance of counsel throughout this case?
Yes, Your Honor.
According to your plea bargain agreement, in exchange for your plea of guilty to theft, 2,500 to 30,000, state will recommend 8 months in the state jail. You will get credit for the time that you have served. Is that your understanding of the agreement?
Yes, Your Honor.
And would you like to enter into that agreement now?
Yes, sir.
To the charge of theft, 2,500 to 30,000, how do you plead?
Not guilty. I mean, guilty, sir.
Okay, let's do that. I'm gonna ask the question again so it's clear for the record. To the charge of 2,500 to $30,000, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for
Yes,
no other, let me finish. Are you pleading guilty because you are guilty and for no other reason?
Yes, sir, I am guilty.
State, have you given notice to the victim in this case of the proposed resolution?
We have notified the victim of the pending case. I don't know that we have notified them of the final resolution of the case. However, it does not appear that they requested any additional contact.
Thank you. Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt, and I find that you are guilty. Counsel, is there any legal reason we can't proceed to sentencing at this time?
No, Your Honor.
Nothing from the state.
Any argument from the defense?
No, Your Honor.
Having found you guilty of theft, 2,500 to 30,000, the court sentences you to 8 months in the state jail facility. You will get credit for the time that you have served. Is there anything else we need to take up?
Nothing from the state.
Not from the.
Sir, I have followed your plea bargain agreement, and because I have, you do not have a right of appeal. I'm signing the trial court certification that will go into your file. Good luck to you, sir.
Yes, sir.
Can you borrow your right thumb real quick?
Thank you, Judge.
Straight up,
Thank
straight
you.
down.
Good to see you.
Straight up, straight down in the box. There you go. Perfect.
Hello, Mr. Mendoza. Who do you have today?
Judge.
A lot of them. It's your
First one's Marilyn Jones, Judge. I have a signed waiver agreement.
moment, please. Ms. Jones here.
She's in custody, Judge.
For what?
Possession of controlled substance. And 2 charges of marijuana and I believe the marijuana has nothing. That one's not filed, is it?
I've signed that waiver.
The other
Very good.
case, Judge, I have Samuel Cuellar, Cuellar.
Yes.
We have
Is he up here?
he's in custody, Judge.
Okay, we need to get him up.
That's fine.
All right. Who else?
Devin Gallegos, Judge, I've gone over the paperwork, PSI report with him. He's
Quiet, please.
ready to be brought up.
Okay.
And we can finish that out, sentencing.
All right, let's get Gallegos and Cuellar, please.
And then also have Rangel, Judge. We can put that at the end of the docket call if you want. That's the bond hearing.
I would appreciate that.
No, that's fine.
Okay, we can do that.
That's all good.
Very good. All right, when they get them up and you've talked to them, just let us know. All right. Yes, how you doing?
I'm doing excellent. About yourself, Your Honor.
Good, thank you.
Good. I'm here on behalf of Rolando Solis.
Mr. Solis, can you come forward, please? How you doing, sir? All right, you okay?
Yeah.
Are you clean right now? Yeah, if you were tested for drugs, would you test clean?
Yes, sir.
Okay, I'm gonna send you down for a test real quick. All right, are you tired?
No, it's cold.
You're just cold?
Yeah.
And that makes you this way? Okay, all right. Well, someone from pretrial services is going to take you down to get a test for me. You sure you're gonna be clean? All right, very good. Well, I'm happy to hear it. We'll come back on this case after that's taken care of. Can someone from pretrial services direct that for us? Thank you. Step over there, sir.
Be back in just a moment.
Thank you. Yes,
Fine.
I'm here on Mark Herrera,
Herrera.
and we have an agreed reset with the state if the court is okay with that.
Mr. Herrera, can you please approach?
Judge, the reason for our request for reset is to look into some treatment options and to do some upfronts.
Okay, sir, would you be clean right now?
Yes, sir.
Last time you came in, that wasn't the case, was it?
No.
Right. Also, let's go get you tested real quick, okay? Sure you're gonna be clean?
Yes, sir.
I'm happy. That last time worried me. I remember you weren't the same look as you have right now.
Yes, sir.
Have you been getting treatment?
I've been getting some other kind of treatment for stuff, depression, stuff that I'm going through.
Okay,
So they kind of run together a little bit.
okay. Can we also assign pretrial services, not just to get a test, but to oversee him? The reason I want that is because what it means is that they can start helping you get some treatment on the substance abuse side.
Okay.
Okay, and I think that would be helpful. And while we're waiting for this to move forward, before we decide what we're going to do with this reset, be in touch with them. Go down, take a test. When you come back up, we'll make a decision.
Okay.
Understood?
Thank you.
All right. Thank you. Do you have anything else?
That's it.
All right. It shouldn't take too long. Hello. Yes.
So I am here for the sentencing of Miles Williams. He did go get that UA. It did come back negative.
Great.
So we are ready to proceed, if you are.
Okay. Did you review his version of the events?
I did, Judge. We
And
had,
are you ready to discuss it on the record? Because I cannot accept a plea if he is saying what he did was not knowingly discharging the firearm.
yes, Judge, we have had extensive conversations about it and we are ready to.
Okay, great.
And I would also add, Judge, as far as the UA goes, he did take it upon himself to go get tested. I don't know if you want a
Sure.
copy of it, but just figured we'd provide that to you as well.
I'm assuming you're showing me a clean. Yeah.
Yes. Oh my God, that would be so horrible. And then my client is just.
All right.
Good morning, Your Honor.
Good morning. How are you doing?
Doing fine.
Good. Are you working right now?
Yes, sir.
Where are you
I'm
working?
working at 2 jobs. I just got a job at Raising Cane's.
Okay.
They had a grand opening in Austin, Texas, and Sunset Valley. Sorry. And so I just got hired for that as a cashier. And then I also work from home job. I don't know if you ever get those calls for like the presidential campaign.
Oh, yeah.
Even though the election's over now. So that job is just seasonal. So right now, just Cane's, Raising Cane's.
Okay. Very good. I'm happy to hear that. I saw the one about the making the calls.
Yes, yes.
How
I
was
at
that?
That was a really good job. The election was really good, and it was a good experience because it gave me like speaking skills,
Yeah.
and, like hospitality, and it goes in with my other job at Cane's.
Good.
So like I'm able to hold the door open for people and like greet customers and stuff like that.
Very good. I'm happy to hear that.
Yes, sir.
These are positive things. Because there's some things on here that are not so positive,
Yes,
right?
sir.
And I hope this means that what you're showing is that you've turned a page.
Yes, sir.
That'd be great.
Yes, sir. I'm on medication as well now.
Okay. All right. Ready, Ruby?
Yes, sir.
Court calls CR 24-1815F, the state of Texas versus Miles Williams. Can council please make their announcement for the record?
Allison Boost for the state.
Courtney Stout for Mr. Williams.
Mr. Williams, we are here today for the sentencing on your case. Are you the same Miles Williams who pleaded guilty to deadly conduct, discharge firearm?
Yes, Your Honor.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, you can put your arm down. I've received a pre-sentence investigation report from the probation office. Counsel, have you had the opportunity to review that report and discuss it with your client?
Yes, Judge.
Are there any corrections or modifications?
Yes, Judge. I would just like to add on the record, I have had multiple conversations with my client about his version of the events that is annotated in the pre-sentence investigation report. And I would like to tell the court that I think my client in the past has had difficulty taking accountability for what transpired. However, he is wanting to take accountability today and does wish for the court to sentence him to the agreed upon terms as outlined in our agreement.
Okay, let's be specific. In your version that you gave to the probation,
Yes, sir.
you maintained that what happened on this day was an accident. You didn't knowingly shoot off the gun. The charge made by the state to which you pleaded guilty was that you knowingly discharged the firearm. And so I have to reconcile those two. Are you taking responsibility for knowingly discharging the firearm?
Yes, Your Honor. I think my words had got mixed up a little bit
Okay.
on the PSI. And so basically, after taking the firearm safety course, I did in doubt see that I'm guilty, and I did ignite with the trigger for it to go off. It was a mistake on my end by not checking to see if it was loaded in the first place. So that's where I think the words had got crossed up in that. But after speaking with my lawyer and my family, after them telling me how safety of a gun works and stuff, I realized that I was wrong at the day of the arrest, the statement I had given, which had made me wrong in that case, and that I am guilty. Because there has to be a force, a cause and effect for that gun to go off.
All right, I'm satisfied with that. Are there any other modifications or corrections to the report that you want to bring to the court's attention?
No, Judge, thank you.
Is there any legal reason we can't proceed to sentencing?
No.
Nothing from the state.
Defense, any argument?
No, Judge, it is my understanding that probation is or their recommendation was a deferred. I will just note that we did not negotiate a deferred agreement. We negotiated what is outlined in the plea agreement. If you were so inclined to provide him with a deferred, that would be great, but that, just so it's clear, that was not negotiated. We negotiated standard probation.
Based on the history and the pending case in Travis, is that case still pending?
It's not pending. He is on deferred adjudication still.
Okay. Is there a motion to adjudicate pending?
I believe so. That has not been resolved. They're waiting to see what happens in this case.
Okay. You recommended deferred. Do you want to be heard on that?
Correct.
Can you tell me your name for the record, please?
Cody Hernandez for probation.
I'm sorry.
Cody Hernandez for probation.
Thank you.
Okay.
Our recommendation is deferred because of the criminal history, no convictions, no extensive criminal background. So that's why our recommendation is deferred instead of standard.
Okay, I'm going to follow the agreement in the case and sentence. Is there any legal reason we cannot sentence him at this time?
No,
Nothing from the state.
Okay, I'm going to follow the plea agreement. Sentence you to 10 years in the Texas Department of Criminal Justice. That will be suspended for 7 years. There will be a fine, a fee, court costs that are due today. You have 200 hours of community service restitution. You will do regular UAs, the moral recognition therapy course. I think that would be helpful to you. You will be on the specialized caseload as indicated in the recommendation, and you may possess no firearms or ammunition during this term. Understood?
Yes, sir. Yes, Your Honor.
As I read in here, there was a backpack that had multiple guns in it.
Yes, Your Honor.
Where are those guns now?
They're still in evidence.
All of them were taken?
Yes, sir.
Okay. Do you have any other guns?
No, sir.
All right.
And it was two in the backpack.
All right. Well, then you are not allowed to possess any firearms or ammunition during the terms of this probation. Is that understood?
Yes, sir.
All right. And did I see also that you have a high school diploma?
Yes, sir.
Very good. All right. Well, it sounds like you're doing well. I'm proud of you.
Yes, thank you.
Keep it up, and you won't have to come back here again.
All right.
No guns.
That's right.
Yeah.
Right. Yeah, I don't think that
Thank you,
guns
Your
are
Honor.
an area that you want to be messing around with, given what I read here. Anything else?
Nothing from the state.
Mr. Williams, I followed your plea bargain agreement. Because I followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. That will be added to your file. Proud of you. Good luck.
Yes, sir.
All
Thank
right.
you, Your Honor.
Mr. Williams, I need to borrow your right thumb. There you go. Straight up, straight down, and then straight up, straight down in the box. Don't need to roll it, just straight up, straight down. There you go. Lift it up. Perfect.
Thank you.
Sally,
Uh-huh.
have a good day.
You too.
Thank you, Your Honor.
Thank you. Oh, no. Have you moved away?
It's broken? Oh, no.
This is just kind of one of the final nails in the coffin. We don't have.
Well, they were like, we're gonna just use all paper, but now if the machine's broken, the parts are too expensive, so
So does that mean it won't be used again? Completely? Or are we gonna fix that thing?
knock on wood.
That it won't be used?
Yeah.
No.
Nice.
Yes.
Sure. Order that key.
Okay. Thank you. Hello, how are you? Great.
Time. I can leave the folder and
Yep, I'll take a look at them.
yeah, questions you can call on.
Yes, sir. All right, thank you very much.
Thank you, Jeff.
Yep. All right, yes,
May Mr. Solis approach as well.
yes.
Wanted to bring something to the court's attention. Mr. Solis, please approach again.
That was Miles Williams, we just said. What's going on?
Make a confession.
Yeah, you're gonna test dirty?
Yeah.
Yeah, I know.
Marijuana.
Did, for what else?
That's it.
When was the last time you used?
And 2 weeks ago.
Huh?
I believe.
Please speak.
2 weeks ago, I believe.
2 weeks ago? Okay,
Yes.
did you take the test yet?
Not yet. We wanted to let Your Honor know before he went downstairs.
Fair enough. I'm glad you did that.
Yeah.
All right, that's gonna help out. And all right, well, let's go get that test done.
Thank you very much, Your
Thank
Honor.
you. How you doing, Mr. Matias?
How you doing, Your Honor?
It's Mr. Matias Day in here.
Yes, I got 5 cases.
I know.
I'm gonna run through them. The first one, Alonso Martinez, it's arraignment today. He's not here. I believe he's in. Quiet, please.
He's in ICE custody?
Yes, according to their county website, just released to other agencies. Says.
Vicky, are you on that? Okay.
Ready? Next one.
1 second. I just want to see.
Sorry, who is that? I totally blanked on the name.
Alonso Martinez. I have.
Is Mr. Vestal here?
I have them as Alonso Martinez.
This is on Christopher Ramos. It was his case.
Sometimes you guys have. Did you find them?
I got the waiver.
Yeah.
Okay.
Just have it all together.
I've signed the waivers, the point I'm trying to make here. And then Mr. Dudley on William Baker.
I saw him downstairs, Jeff.
Okay,
Tell you,
sign the waiver on that one too.
Dominguez Lara,
Mhm.
you made an offer of 5. He says. I got
Baker,
2 and
Page 2, number 1.
That was for my 4th DWI. Why should I get more here?
And the other
When it's
is
only my 3rd DWI?
Ramos
Because our juries will.
signed the waiver of that.
And next time, call him when he's gonna drive drunk.
Page
you should
7.
say in Caldwell.
My counter offer is 2.
Rejected.
Okay.
I do 4. You got something out of
You do
me.
4?
I do
Okay.
4.
Okay, we'll reset it for now and now.
Okay,
Continue talking.
I'm sorry, on the arraignment on. Mr.
Alonso.
Oh, he's not here. He's not here.
He's, I believe, in ICE custody.
Okay.
The next case,
Yes, sir.
Dominguez Lara. I just made it, I just made a counter offer. It was rejected. I like another pretrial, just one more. Should be. I'll talk to him some more. I'm assuming it's agreed.
Let's get him up here, please.
I got it.
I'll take care of those 2. Are those both yours?
Yes, sir.
Okay. And then next,
I got, they're all, Flores Velasquez. I just got a plea offer. We have an agreed pretrial setting. It's a different offer because it was at one point on the announcement docket, but he failed to show up. And after, I guess, a long time, he got picked up and is now in custody. So there's I believe, a new plea offer on the table.
okay, we'll get him up. Next,
And the another one is Romero Gonzalez. He failed to appear, Your Honor. He is not in custody. He was here for, today's his arraignment. I have no contact with him.
have you ever had contact with him?
No. Romero Gonzalez.
Becky, do you see that he received notice to be here?
Notice is sent to the attorneys.
I did get notice.
All
I'm
right.
here.
Very good.
I did not know.
All right.
The next one is the big one. Torres Padron. He wants to make an open plea to the court. We have a translator standing by.
Okay,
Torres Padron,
very good.
open plea to the court.
Have you already done the paperwork?
No, Your Honor, I'm not familiar with open. pleas.
Okay, the state will put
This
together
is-
the paperwork for you and then you'll go over it with them.
Yes, Molly, she'll get the paperwork for you.
This is not very common.
So what I'd like to ask you to do, I'm gonna take care of these two that are in custody. And if you can, after she gives you that paperwork, you go down and get it and we'll bring all three up. Okay? How are you?
Good. Mr. Michaelowitz,
Michaelowitz?
yeah. Do you want full sex offender conditions or just the treatment?
I mean, I
You're-
would lean more to the side of full.
Okay. So,
What do you recommend?
well, he did have relations with a 13-year-old and it was reduced to entry to a child.
Yeah,
So I have full sex offender conditions if we want to get all the parties involved.
yeah, well, we'll bring up counsel and see where what arguments can be made.
Okay,
I mean, I think we started this in some ways during our hearing.
hopefully.
But at the end of the day, injury to a child is what state proceeded on, so
Correct.
I feel somewhat bound by that.
Yeah.
Okay,
Perfect.
thank you.
Question?
Yes,
This first one will be Samuel Cuellar.
Mr. Cuellar, come on up. What are we doing on Mr. Cuellar?
Good. Or good.
Yeah, Judge, we have a motion to dismiss for his two felony charges that are currently pending. After reviewing evidence, state believes that there's insufficient evidence to go forward on those two charges. And we've got a time served plea down on his misdemeanor cases that are currently in intake, ready to go instead.
Okay, the two charges are endangering a child. Do you have the file?
It's 2 counts of endangering.
Endangering child, imminent danger. And does the victim or the victim's guardian know of this resolution?
Judge, we've not informed her of this resolution, but she is also the victim in the misdemeanor cases that we will have a plea agreement on. So,
Let's reach out and have somebody try and contact her today.
okay,
Can we make that call right now?
we can.
I mean,
Yeah.
maybe one of your
Sure.
victim people, so that I can feel comfortable on that question.
We have a person for that.
Good. Who is that?
They haven't quit or gotten promoted yet.
Well, good for all the people getting promoted. Good for them.
And Judge, if the court is to go forward with, does proceed with the dismissal, it's acceptable. I was gonna ask the court to keep Mr. Cuellar here in Hayes County, that way he doesn't get transferred to Haskell or anywhere, because they're gonna try and get his cases resolved on this Thursday jail docket.
So if I dismiss today, I will have no jurisdiction over him.
That's fine.
But let's see, let me just get this answer
Okay.
and I need to get the answer to that
All right,
question.
that's fine, Judge.
Okay.
And then we have Mr.
Very good.
Mr. Gallegos is
Mr.
next.
Gallegos? What are we doing with Mr. Gallegos?
But since Judge, I've gone over the PSI with him and the conditions of probation. And he signed them, I've signed them, and I give the copies back to probation.
How you doing, Mr. Gallegos?
Good.
Good. Are you taking your medicine?
Yes, sir.
Okay, how do you feel?
Good.
Good. All right. What are we here to do today?
Check over my probation.
I'm sorry?
They asked what the questions they asked me in probation.
Oh, yeah, the probation came and spoke to you. That's right. And then what am I here to do today?
Sentence me.
Okay, sentence you. That's good. And so what does that mean? What does that mean that I'm going to do? Do you understand?
Give me home, right?
What's that?
Give me home.
Give you home?
Give me home.
I'm sorry,
Get me home.
get you home?
Yes, sir.
Okay,
And Judge, if I may, sorry, interrupt briefly. I did speak with his mother. The meds that he's taking is causing him to shake a bit. He has to take an additional medication that I don't know that he's receiving right now, which is why he's having difficult talking a little bit. So if he's struggling, that's the reason why.
okay. Well, what I'm asking these questions for is to make sure that you understand what's going on here today. And it sounds like you do. You know, you're here for your sentencing, right? You know what your sentence is, or you know what has been recommended by going through the report. Is that right?
Yes, sir.
And you've discussed all that with your attorney?
Yes, sir.
All right, very good. Now, if I follow this agreement, where will he go?
He's gonna live with his mom, Judge.
Okay, is his mom here today?
Yes, sir.
Okay, very good. Why don't you come on up? And Donkey, let's just put her over here to the side. Just put over here. Be ready, Ruben?
Yes, sir.
Court calls CR 23-1002F and CR 23-0181F. State of Texas versus Devin Yvonne Gallegos. Can counsel please make their announcements for the record?
Allison Boost for the state.
Anthony Mendoza for defense.
And are you the same Devin Gallegos, who in CR 23-1002F is charged and pleaded guilty to assault on a public servant?
Yes, sir.
And the same person, the same Devin Gallegos, who in CR 23-0181F is charged with harassing a public servant?
Yes, sir.
Is that you?
Yes, sir.
And you pleaded guilty to that case as well, right?
Yes, sir.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, we're here today to do your sentencing. I have received a pre-sentence investigation from the probation department. Counsel, have you had the opportunity to review this report and discuss it with your client?
Yes, Your Honor, I reviewed it and I read it to my client.
Are there any corrections or modifications?
No, Judge.
Is there any legal reason we can't proceed to sentencing?
No,
State, any argument?
No, Your Honor.
Defense, any argument?
none.
All right. And let's just go over a couple of things. We've been back and forth for a couple of years now together, and you seem to be understanding today what's going on. Is that right?
Yes, sir.
And what are we doing today? What are we here for?
Probation.
For probation, is
Sentencing.
that's what you're going to get? But sentencing, is that what you're telling me?
Yes, sir.
And what does that mean? What's going to happen?
I'm gonna be put on probation.
Okay. And who is going to do that?
My appeal.
Well, the PO will oversee you, but who is going to give you that probation?
You.
That's right. And then this person over here to your left, who does that person represent?
The DA's.
The DA's office. Good. And what is the DA's office's role? Okay. And to your right, who's that person?
My attorney.
Okay. And what is his role?
For defense.
Okay, very good. All right, so now we're to the point of sentencing you. I find that you understand what is going on and are capable of being sentenced today. Counsel, do you believe that your client is competent to be sentenced today?
Yes, Judge, I do. As I reviewed the documents with them, I read them in their entirety. I asked several follow-up questions to make sure he understood, and it's my belief that Mr. Gallegos did understand the paperwork, understands the proceedings today.
Very good. All right. Having found there was sufficient evidence in CR 23-0181F, harassment of a public servant, the court now sentences you to 7 years deferred adjudication. There will be a fine, a fee, and court costs. You will do 100 hours of community service. All of that will run concurrent with CR 23-1002F, assault on a public servant. I found that there was sufficient evidence in that case, but I do not make a finding of guilt. I grant your application for deferred adjudication in that case as well. That will be for 7 years. The same conditions will apply. Additional conditions will be that you will take UAs. Do you have a diploma?
No, sir.
Okay, I want you to work on your GED.
Yes, sir.
All right. Have you been doing any of that while you've been in custody?
No, sir.
All right. But let's start getting to that. All right. It
Yes,
takes
sir.
people different amount of time, but what if we aim for about 2 years to get that done so
Yes,
that you
sir.
have a goal,
Yes, sir.
right? If you get it done in 6 months or you get it done in 1 year, that would be even better.
Yes, sir.
All right. Then we want you to do the anger intervention course. All right. So we don't have these situations if you are interacting with law enforcement again,
Yes, sir.
right? Because that's what got us into all of this is these interactions with law enforcement, right?
Yes, sir.
And what are you going to do different if you're in the presence of law enforcement in the future? Behave? And what does behave mean?
Stay on my meds.
What's that?
Stay on my meds.
Stay on your meds. Great, great. That's going to help you to behave. But when you are interacting with law enforcement, what are you going to do different than these previous cases?
Not sure what that means, sir.
Okay, when you say that you behave when you're with law enforcement, what does that mean?
Stay on it.
Stay, I'm asking, maybe, will you be respectful towards law enforcement?
Yes, sir.
Because the things in these cases were not very respectful, right?
Yes, sir.
And so that's what I'm asking. Let's go in a new direction where we're respectful to law enforcement,
Yes, sir.
right? And what does being respectful to law enforcement mean to you?
To be respectful.
To be respectful to them, what does that mean to you?
So not get in trouble with them. or
Not to get in trouble with them, that's right. But how do you treat them?
With manners and respect.
With manners and respect. Good. And are you at a place where you feel good that you can do that?
Yes, sir.
Good. I hope so. Next, we're going to have you in the specialized caseload as indicated in the paperwork. And when you are on probation, what is your plan for where you're going to live?
With my mother.
With your mother, and your mother's here?
Yes, sir.
All right. Are you ready to help him?
Yeah.
All right. Well, it's been a long time since you've lived with her.
Yes, sir.
You're going to treat her with respect.
Yes, sir.
And what does that mean? What does it mean to treat your mother with respect?
Do the same with law enforcement.
Well, and what does that mean?
So respect her.
To respect her, right? What else? What does respecting her mean to you?
Like treat her with respect.
Treat her with respect?
Like
Yeah, but what does it mean to treat her with respect?
use my manners with her.
Use your manners with
help
her.
around and stuff.
Help her out. That's
Yes,
good.
sir.
Help at the house because you're going to be living there.
Yes, sir.
Awesome. And love her too, right?
Yes, sir.
I mean, she's here for you today.
Yes,
She's
sir.
been here for 2 years. She's been coming here and helping.
I
So
know.
she cares about you a lot.
Yes, sir.
I know that. You know that too, right?
Yes, sir.
Good. While you're there, we're going to ask you to participate with the Texas Workforce Commission. That means that you'll be with your probation officer. They're going to try to help you get a job.
Yes, sir.
All right. And they can help you look in a lot of different places that might be the perfect fit for you.
Yes, sir.
All right. And then I want you lastly to make sure that you continue to take your meds.
Yes, sir.
All right. We were at a time where you may not remember it, where you said, I didn't want to take my meds.
I remember.
You remember that?
Yes, sir.
Good. But now you're taking them and you seem like you're doing a lot better. Are they helping you?
Yes, sir.
Good. I'm proud. All right. Well, that's everything we have. Is there anything else we need to take up, State?
Nothing from the state.
Defense?
That's from defense.
All right.
So I just wanted to know if there's a timeline of when is he gonna be released today or is that be tomorrow? Do you know?
I won't make that decision, but I'll sign whatever they give me in that sense. He has to be processed and everything.
I just wanted to let him know he was curious, so that's fine, dude.
No, it's fair for you to be curious. They'll let you know. And they have to go through some paperwork.
The jail.
The jail will.
Oh, yes, sir.
Okay. All right. I have followed your plea bargain agreement, Mr. Gallegos. And because you do not have a right of appeal, I'm signing the trial court certification. That will be added to your file. That's in both cases. These cases will run concurrent. Are you appointed?
Yes, sir.
All right. There will be no attorney's fees assigned in this case. Anything else we need to take up?
Nothing from the state.
That's from defense.
All right. Good luck to you, sir.
Thank
Keep
you.
doing all those things, treating
Yes,
people
sir.
with respect.
Yes, sir.
All right.
Mr.
Good luck.
Gallegos, real quick, can I borrow your right thumb? I just need you to go straight up, straight down, and straight up, straight down in the box. Perfect. Can you do this one for me, please?
Move it to them all.
Thank you very much. Do you want to give that to me first?
Remember the beginning of that one? We've been working on that case for 2 years. What's that? Yeah. And I've remembered him all along. I'm happy that we got some resolution. Mr. Matias.
The Flores Velasquez case, Your Honor, Becky needs guidance as to what docket we're moving it to. I suggest the plea docket. It was on the announcement docket.
Where is he?
He's in custody. He was just recently incarcerated after failing to appear for the announcement.
Is he up here?
docket. No, he's not up here.
Okay, we need to get him up here. We need to get all of the defendants that are yours that are in custody up here.
But you agreed to a reset. I said the plea docket.
Well, I need to know the case. I just
Okay,
don't know.
all right.
And I want to do it in front of him. It's his.
The plea docket already?
Okay, all right. But we need to do it with him here.
Sure.
His day in court. It's not my day. It's not the state's day. It's not the court's. It's not the defendant's day. Defense's day. Defendant's day. It's definitely the donkey day.
That's it.
All right.
Deborah?
Yes.
I have Christopher Williams, Judge.
Mr. Williams?
Yeah. I already have him spiel.
Is he served custody? I mean, has he been in custody?
No, he's out of custody.
Quiet, please.
So previously he was sentenced, Judge, and it was as part of the condition of probation is for an additional 23 days of jail, which he's already served and was released, probably a couple days ago.
Yeah, on Tuesday.
So,
So-
we're sentencing after?
Yeah, so Judge, what's going on is, so he was previously sentenced. And the reason why we proceeded with sentencing is because we had worked out the conditions of probation. One of those conditions was 120 days in jail. He served 97 days previously. So one of the requirements, he served his additional 23 days. The court wanted a PSI just to look at any additional conditions. But he has already been sentenced. But there's a couple of neat things we need to address. Specifically, he still has an ankle monitor on. We're asking for that to be removed. And then his version of the events.
Yeah. Yeah, because that is a problem here.
Yeah.
And the victim's family also wanted to be present for sentencing. So that was part of why we went ahead and sentenced him, but we haven't finalized it.
We sentenced but didn't sentence.
Correct.
So are we sentencing?
Yeah, he's technically been sentenced. It was mainly for the court to consider because any additional conditions. And specifically with his version of events, I've talked to him about it whenever the court's ready for the explanation.
Okay.
And is there a judgment in there already?
Yeah, I think there's a judgment. It's
Okay. So I feel like I had done one.
yeah, I see it right there.
What did we proceed on?
The tampering, Judge.
So I've already dismissed or signed the dismissal motion for the murder and aggravated assault.
Correct, Judge. I believe so.
Mr. Williams, can I borrow you write them from straight up, straight down, and then straight up, straight down in the box?
Rudy, are you ready? I guess, however, before we go on the record, I don't, given that the murder case was dismissed and the ag assault was dismissed, the defendant's version only needs to go to the tampering.
Correct, Judge.
So it seems, was there an issue with the tampering in his version?
No, Judge. So the original allegations were that when this case was originally filed, the allegations were that Mr. Williams had taken the gun and had tossed it in the lake. And so through trial prep and investigation, conferring with the state, came to find out what actually had happened is when Mr. Williams had left the scene and gotten back into the vehicle and got back to Austin, he was dropped off at his car and he left the gun and handed the gun to another individual in the car. And then that person ended up disposing of the gun. Because originally it was thought that Mr. Williams had tossed it in the lake. And so when I had discussed that with them, a lot of times people think tampering is actually physically doing something as extreme as tossing in the lake. And if I could explain to him that there is case law that supports just handing the gun qualifies as tampering. And after I talked to him about this morning, and we discussed it last time, he was like, oh yeah, I totally understand. So he understands that it qualifies as tampering and he takes responsibility for the offense.
And there's also case law that says that removing a firearm from a scene where a shooting has occurred, even if the subsequent shooting is found to be justified by self-defense, you're still not allowed to remove that firearm from the scene. So.
But is there anything in the defendant's version here that is counter to that?
No.
No.
I didn't think so.
No.
So is there anything that you said you wanted to put something on the record?
Well, just says as far as he talks about at the end, as far as he doesn't remember anything being tampered with. That's the only thing I just wanted to clarify.
Yeah, okay.
And it was just a matter of him just thinking tampering, you think you actually like tossed, because that was the original allegations.
Okay, Rudy, are you ready?
Yes, sir.
Court calls CR 210921D, State of Texas versus Christopher Williams. Can counsel please make their announcements for the record?
Allison Boost for the state.
Kyle Lynch for Mr. Williams.
And are you the same Christopher Williams, who was originally indicted on 2 other charges, and then ultimately in count 3, you were indicted on tampering with physical evidence and pleaded guilty to that?
Yes.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, we're back here today just to finalize the sentencing, and by that, I think it was only to take the judgment and get your fingerprint for it, and to do any further conditions after the court received a report. I think, as I remember, we were set for trial.
Correct,
At this very last minute, but it was for probation. Everyone wanted to get the sentencing in, but I had not had the opportunity to review all the conditions and make sure that they were, that everything was included. Is that right?
That's correct, Judge.
That's correct, Judge.
All right, and one of the things that we looked at, since we're moving forward only on the tampering, in his version of events in the report, there's some discrepancy. Would you like to discuss that?
Yes, Judge. So the original allegations were that Mr. Williams had tossed the gun in a lake, and through trial prep and investigation, came to find out that that did not occur. It was a matter of Mr. Williams leaving the scene with the weapon and then handing the gun to one of his co-defendants. I've discussed that with him because in his mind, he was thinking the tampering aspect was tossed in the lake, but leaving the scene and handing the gun off after a shooting occurred qualifies as tampering, and he fully understands that and takes responsibility for that.
Is that right, sir?
Yes, sir.
Anything else on that issue you need to take up?
Nothing, not on that issue, Judge. No.
Very good. And then on the conditions, we've already sentenced you in this case to 10 years in the Texas Department of Criminal Justice. That was suspended for 10 years. In addition, We want you to do frequent random UAs. You will do the community service restitution. Did I already give that amount on community service? Do we have the days?
16 hours per month, 200 hours
200 hours total?
for community service, yes.
But I already did that. Is that the agreement or is that what the court imposed?
That is what I have here in the agreement.
Okay, there will be 400 hours of community service restitution. You will do the cognitive education program, the moral recognition therapy program. The jail as a condition, we already sentenced, and that was for 120 days. And you will have no contact with the individuals involved in this case. I see that as Jeremy Spivey, Rebecca Gonzalez, Ryan Carmona, Ina Lisa Blackman, Sarah Blackman, and Michael Ifianacho. Do you know who all those people are?
Yes, sir.
Do not have contact with them. Do not have contact directly or indirectly. Don't text, tweet, talk to them on social media. Stay away from those people. Understood? All right. Is there anything else we need to take up?
Your Honor, I would just state on the record that Michael Ifianacho is set on today's docket, so he is present. I don't consider that to be a violation of Mr. Williams' conditions. However, I would advise Mr. Williams and ask the court to second that if you run into Mr. Ifianacho outside of the courtroom, that you just walk away, because any additional contact would be a violation.
Yes.
Okay, yeah, be in the same courtroom. It's not on you, but don't have any contact with them. Understood?
Yes.
All right. Is there anything else we need to take up?
Yeah, just the only thing, just he still has a GPS on, I just asked that from you. There was a condition for pretrial, but it wasn't anything that was discussed as far as a condition.
Has he had any violations of his GPS monitor?
Zero.
He is not, Judge.
Okay, all right, that can be removed.
And the only other thing is that, I've already discussed with this probation, philosophy had to transfer to Travis County.
Okay, is that where it's gonna be?
Yes, sir.
All right, make sure you're taking care of business there.
No worries.
All right, good luck to you, sir.
Thank you, Judge. May I be excused?
You may. Thank you. Did I have another case of yours?
Rick covered for me. He already did the waiver. Christopher
Okay.
Ramos.
Okay, very good. Here, that's yours. You ready, Miss?
Mr. Herrera did go downstairs and he's back up, and I guess we have the result.
Mr. Herrera, come on up, please. All right. How'd it go?
Good.
You were clean?
Yes, sir.
Awesome. All right. And now pretrial is also going to take over supervision. Is that right? He's already in pretrial. Okay. And so we were talking earlier about getting you some treatment with them. Have you talked to them about that?
No, I haven't, but they know about the integral care that I'm going to.
Okay.
They know about that.
And is that for substance abuse?
It's for both, like depression and kind of loop together.
Okay. Yeah, because drugs are not going to help with those issues,
Yes.
right? We know that. Well, good. I just want to make sure that you're getting something in the interim while we're waiting for this case to be resolved,
Okay.
and that you are getting some support. And sounds like they are already doing that.
Yes, sir.
If they come up with new programs for you, I hope you will take an interest in doing them, because they're there for your benefit. Okay.
Yes, sir.
All right. We're here. Okay, you wanted to be heard? I said you wanted to be heard about what we're doing.
We're just requesting a reset on this, for that very purpose that you just stated.
The purpose of,
For the purpose of, that you just stated with getting him some treatment and getting on board with that.
okay, well, let's go ahead and get it. We're gonna move this to a trial setting. So the next setting, when we come back, you will be set for trial. Does not mean that you shouldn't go ahead and get treatment started, and maybe that will be part of your agreement. I don't know. But that will, because this is a plea setting, I think I've told you before, a setting after that would be a trial setting.
Yes.
Understood?
Yes, sir.
Okay. Anything else we need to take up?
No, Judge.
Yes, you may. Thank you for your patience today. Good to see you again. Hello, Ms. Dow, who do we have you?
Alfonso New.
How's your husband doing?
Good, actually.
Good, glad to hear it.
All that's fixed.
What's that?
I said all of that is fixed.
Good.
Thank you.
Happy to hear it. How you doing, Mr. Newth? All right, sir. We're here on a pre-trial setting today. Anything that we need to take up?
I don't believe so, Your Honor.
Okay. We were here. Have you started the GED program there? Yes, sir. Good. You asked about it. Yes, sir. And you're doing it? I'm happy to hear that. All right. Is there anything that's outstanding that we can't start moving this towards please setting?
Judge, we would like one more pretrial just so that we can get contact with our victim to discuss potential counteroffers that have been made. And so we would ask for one more. This has only been indicted for a month and a half, so I don't think we need to move to a plea setting just yet.
Okay, very good. So your attorney was up here. I just wanted to bring you up so you know what's going on in your case. It's your day in court, not ours, okay? She made an announcement. She's been conferring. She's been taking care of you, but you get to come up and see what's happening. All right, is there any questions you have? No, sir. Very good. All right, thank you very much for your patience, Ms. Dow.
Thank you.
Thank you. All right, yes. On Cuellar?
We are, yes.
State, I had asked on Cuellar if the victim or the victim's guardian had notice of the intention to dismiss the endangering a child with imminent danger 2 counts. Were you able to look into that?
Yes, Judge. The victim was contacted by certified mail back during the indictment of the case and has not reached out to our office since filing. We have tried using the phone number in the offense report even back earlier on. And we're not able to leave a voicemail because the voicemail box was full. We then ran a TLO this morning to get further numbers, and we reached out to a couple of the numbers on that list, and we left voicemails for the victim in that case. I do believe that is enough to satisfy our duty of reaching out to the victim to let her know. I would say that the state's motion to dismiss is due to sufficiency of evidence, and I don't believe we'd be able to prove the 2 felonies, and the misdemeanors are much more appropriate vehicles, I think, for this. We'll continue to reach out to the victim in those misdemeanor cases, but that's the update from the state.
Thank you. Thank you for all of those efforts that you made and comfortable signing and have signed the motions to dismiss on both felonies.
Thank you,
All right.
Judge.
Is there anything else we need to take up?
Nope.
All right, very good.
Thank you, Judge.
Thank you for doing that.
Yeah, no problem.
All right,
Yeah, reaffirm?
yes, Michaelowicz?
Yes, sir. I believe that probation has incorporated all the terms and conditions.
Come on up, Allison and Mr. Michaelowicz. So is there anything that the probation is requesting or the state is requesting or that you're requesting that is outstanding?
I don't believe so.
Probation would just ask for additional sex offender conditions, modifications to be allowed, just to the nature of the case.
Which ones are you asking for?
Basically the no contact, the child safety zones.
The what?
Child safety zones.
Okay. For all children or just for the no contact with the victim in this case?
For all children.
Okay, you want to be heard?
Yes, I just don't think it's warranted. He's been through the evaluation. It wasn't suggested. It's part of the recommendations. It's
The evaluation done by whom?
Dr. Shelley Graham.
Dr. Shelley Graham.
So she reviewed and had the option of recommending sex offender conditions?
They do not make legal recommendations.
Okay. Do they make recommendations of programs for people?
Correct.
And did she have the option of recommending sex offender programs for Mr. Michaelowicz?
Yes.
And did she?
Yes.
Where?
It's the counseling regarding healthy sexual behavior.
That's,
So she recommended counseling. Okay, and is he getting that?
well, no, that is what is incorporated. That's the additional terms and conditions that she was requesting that we went and sat down to talk to probation about, that we have no problem with.
Oh,
It's not sex offender treatment or conditions. It's a cognitive component.
so here's what you're requesting is that counseling that the doctor recommended.
Correct.
Yes.
Okay, and you don't object to that?
No.
Let's make that a condition.
And I believe that they've incorporated that in the paperwork for you to report to sign.
Okay. Are you requesting anything else? I don't want to put you on the spot like that. Here's the thing. What the doctor recommended is what I'm inclined to follow. Especially given based on what the charge was and what he was ultimately filed on. If we're doing what the doctor recommended, and the doctor had the opportunity to recommend even more, but did not, I'm not as inclined. So, are you satisfied with that counseling that we just discussed?
Yes.
All right. Very good. Is there anything else we need to take up in this case?
Were you also asking for the typical restrictions for people that are on a sex offender caseload? Is that what was being asked for?
That's the crux, yes.
Okay, so there's the treatment programs that the doctor made a recommendation on. What the doctor does not make a recommendation on is the additional conditions that are typically part of supervision for someone who has a sex-related offense. So that's, I think, what Ms. Taylor was asking the court regarding.
Okay, well, are you still requesting that, or are you satisfied with the counseling recommended by the doctor?
I would still ask for the child safety zones.
So did the doctor have the opportunity to recommend after the evaluation, child safety zones?
She makes a recommendation on the treatment.
And would that treatment have included, or could it have included child safety zones?
They normally do not make that recommendation.
You're shaking your head.
I've never seen a psychosexual evaluation where they recommend conditions of supervision separate and apart from the treatment aspect.
The conditions that they're requesting are conditions that are assigned to those who do undergo sex offender treatment conditions. There, yes, they don't specifically request that, but that's part, if a doctor were to recommend sex offender treatment, that would be a condition that is normally imposed when they undergo that treatment.
Is this counseling under the umbrella of sex offender conditions?
No.
Yes, it is.
No, yes, no, yes.
She is a licensed sex offender therapy provider that will be conducting the treatment.
But it is not sex offender treatment. It is a cognitive component of that bigger treatment, but she's not recommending sex offender treatment. She's recommending if I might quote directly, the counseling regarding healthy sexual behavior. That's what she's recommending, not sex offender related treatment. Specifically, it says some individual counseling regarding healthy sexual behavior. That's her recommendation.
Okay, I want to follow the doctor's recommendation. That's, we'll leave it at that. If there becomes some reason the doctor recommends based on counseling that it needs to be expanded, then come back to the court. All right.
Okay.
So we're adding counseling to conditions pursuant to doctor's recommendations is what I put in here. All right, you understand what we've been talking about, Mr. Michaelowicz?
Yes, Your Honor.
Have you started that counseling yet?
No, we just got.
Okay, all right, well, make sure that you're cooperating, go into it and participating in earnest. All right, good luck to you.
He's doing his other stuff, but it'll be transferred to Travis and they'll assign him a specific.
Will that same doctor do it?
In conjunction with that, yes, Travis County.
Okay, all right, there we go.
Thanks, Judge.
Yep. How you doing? What are we doing, Mr. Klein?
You're on your trial announcement docket, Kim Blunt.
Oh, Blunt, come on up, Blunt. Were you tested?
Yes, I was.
And what were the results?
It came back as THC, and then she asked me, when was the last time I smoked? And I told her Wednesday when I had gotten back out of the hospital. It's not an excuse, but they told my daughter I was gonna die. I wanted to smoke. And I did, but only smoked 3 blunts. And on the little.
Only smoked,
When
you said
they,
you only smoked 3 blunts?
that was all.
Like, you smoked off of 3 blunts or you just smoked 3 blunts?
No, there was 3 of us and we passed it around.
Okay,
And I asked her the container, does it have the
does the
level?
blunt have THC in it?
Yeah, because it has marijuana in there. You put the marijuana in the cigar and you roll it and you smoke it.
Okay,
I don't, and your test bills doesn't show what kind of level. Is it a high level or a low level? It doesn't show on you guys' PP cups. But like I said, it was last week when I smoked them and I'm still showing positive. I only
Yeah.
smoked the 1 time and it was 3 blunts. I didn't smoke today and then tomorrow. I didn't do that.
okay. Well, one of your conditions is that you should not be
You're
using,
smoking.
right? You know that? Okay. So you will be frequently and randomly tested now.
Okay.
All right. Were we already doing that? Were we already frequently and randomly testing her? She's not on pretrial services? Are you assigned to pretrial services?
I don't know what
Not that I'm
is.
aware of, Your Honor.
Okay.
I think you ordered that she be placed on pretrial
I
when
thought-
she went downstairs.
She had already been ordered, but
Not prior to today that I'm
No,
aware of.
okay,
No,
but
sir.
you are now.
what's that?
To be clear, I want her to be under pretrial services supervision. Okay? They should help you with this, and they're also going to be frequently and randomly testing you. Okay, so don't be using whatever your heart conditions are or your other conditions, they're made worse by using drugs. Do you understand that?
He told me to quit smoking. The doctor told me to quit smoking too.
Right. The doctor knows even more than I do. In fact, I'd follow his advice.
I am.
Okay. All right, let's get back to the point here, though, is that we need to get some resolution of this case because it's continuing to, I would say, complicate your health conditions. And we're at a plea setting, is that right? Or
No, this
we're
is
at-
trial announcement.
Oh, that's right. And is there a plea offer?
Yes.
She doesn't know that there is? She just shook her head.
I don't.
Okay, y'all step back and talk about that, please. Okay?
Okay.
Oh, they're talking about the hallway.
Oh, yeah, I'm sorry. I didn't know what. Yes.
Okay.
Yes, sir.
Do you understand what a plea offer is?
You're making me, an offer?
No, I'm not. The
Oh.
state is making you an
Well,
offer.
the lady is.
That, maybe that lady, or maybe that man, or maybe that other lady,
Oh,
but
to see-
someone who represents the state of Texas.
Okay.
Okay.
To where we agree on something and then we sign it and then.
Where
That's
you have to plead guilty. Right?
Well,
That's-
and look,
Yes, I understand.
I'm not suggesting anything. I just want to know if there is an offer.
Yes, sir, there is.
Because in order for you to waive your rights or to demand that you go forward with the trial, you need to have full knowledge of what is going on. To include, do you know that there is a plea offer?
Yes,
And do you know what that offer is? You do not have to tell me. I'm not asking for that. I'm asking, do you know what it is?
Yes, Your Honor, prior to the last setting.
I'm
we
sorry, I don't
received an offer
remember.
from the state. We declined the state's offer and set it for trial the last time we were here.
Okay. All right. So we need to get this trial done. When can you and your colleagues be available to try this case?
Well,
And it's really not how it goes where I give you the offer where you tell me when you can do it, because we need to move this case forward. She's been waiting a long time in general, and she
2021 is the offense date.
2021 is the offense date. There's victims waiting, there's public interest waiting, and there's her waiting. And I think I told y'all when you took this case that taking it midstream would not be grounds for delaying further her case going to trial. So and again, with all of this going on, another positive, a heart attack. When can we try this case? Can we try it?
12/16?
12/16. All right, set it for 12/16. All right, so when we come back on 12/16, well, there will be a jury announcement for that. If y'all come to any sort of resolution, let me know. If not, then we're planning to go to trial on December 16th. In the meantime, you will be under the supervision of pretrial services. They'll have you fill out some forms today. They'll be in contact with you. Make sure that you're cooperating with them. I think that's really one of the most important things here, are you are getting that help. Because if your health conditions are leading to heart attacks, and then we're going back to substances, that is making everything worse on you. All right? All right, so please cooperate with them.
I will.
Anything else we need to take up?
Nothing for the state.
No, Your Honor.
All right, thank you. So the motion for continuance is granted for the trial setting on December 2nd. Do you have the order for me to sign? Do you have the order for me to sign?
I don't have any hard copies, Your Honor.
Just unprepared for life, Tommy.
In the digital era now. I don't like it though. I'll be honest with you.
How you doing, Case?
Good, how are you?
Mr. Darwin.
I have Crystal Garcia.
She here?
She's outside, so
Can we bring her in,
yes,
please?
she is.
Are you waiting on more people to come up?
I have a quadring judge, just rang out to touch me though, so I'm fine.
Okay.
Towards the end of the docket.
All right. All right, we need to take up some more cases then. And do y'all have
Also
the
have the-
paperwork on the Matias case?
Downstairs.
He took it downstairs, so he's working on it.
And we also have the Edward Ramirez motion to reduce bond as well. Counsel's here on
Just email.
Who's doing that?
Sure.
Okay.
Allison
And where's the
Jones.
defendant?
He's in custody.
Ms. Garcia, can you come on up, please? How you doing, ma'am? We started here at 9 o'clock and you weren't here. Why was that?
I got here maybe 30 minutes later because I work overnight.
Okay. Well, understand that we need you to be here on time because if your attorney's here and it happens that he wasn't here today, but if he were here, we couldn't move forward without you being present. And just keep in mind, look, everyone's watching those sorts of things. Like, can you be here on time? Because I bet you, whatever your charge is, and I don't have it here in front of me, whatever it is, you'd rather get probation than go to prison, right? And so if you're on probation, then the issue is going to be, will she show up and complete that probation? Or is she going to be late to a probation meeting and then that's going to set back other probationers and then it just causes problems? So that's why I'm asking you to be here on time. Okay, I think it helps you. And it also means that the court can carry out business on
I
time.
completely understand.
I'm happy though that you're working. So let's end on a positive. Where are you working?
Amazon.
Okay, good for you. All right, what's our status today, guys?
Judge, I'm requesting a reset. The state was unopposed. I think it's the first pretrial setting.
Do you have discovery?
I do.
Do you have an offer?
I do.
All right. We'll move it to another pretrial setting. Thank you
Thank
very
you.
much. Be on time next time, okay? Thank you. All right, I'll run through some docket. Becky, you want to run through some docket? First page, Alonzo. So he's not gonna be here. So there's two Alonzos. I'm talking about the second Alonzo.
Oh, I'm talking about the first one.
Second Alonzo.
I just saw Mr. McCormick.
Have y'all conferred with him?
We have, Judge, I think he's outside speaking to his clients.
Okay. Mitchell Bailey. Mitchell Bailey?
Oh, Judge, I believe, Mr. Bailey is in Tarrant County in custody.
Okay. We are signing dismissal. Dominguez Laura. We're gonna bring him up. Timothy Inholt. Timothy Inholt. Deputy, please call that 3 times.
Yes, sir.
Can you tell if he had notice to be here? And can you tell me actually what the bond is on that one? 7,500.
He signed a reset notice, Judge.
Okay, please increase the bond to 10,000.
Yes, sir.
Inholt.
Yes, sir. Yeah.
Fernandez Morales. Is that what you're on?
2, Judge, if I may approach.
Okay, so we need to get him up then.
Well, he was just gonna ask for a reset for more time. He's,
Fernandez Morales is?
yes,
Okay, well, I need to get him in court.
sounds good, sir. I just finished talking to him.
Fernandez, great. Fernandez Morales, please.
The other, if you want to just discuss that before he gets up here, is Patrick Walters. He's in custody in Travis County currently. I spoke with the prosecutor, Mr. Godera, that's in charge with this case. He, less and better terms, he's just insane. He's been insane for a very long time. He's had some cases in Travis County opened and then dropped because he's never become competent to stand trial. The federal government's got involved at one time, Secret Service showed up, that sorts. Well, now we've gotten rolled into it as well. He has an unauthorized use of a motor vehicle here, got out on bond, caught a aggravated assault with a deadly weapon in Travis. They're asking if you can pull his warrant from us so they can send him to a mental health facility and then go from there.
State.
Judge, I haven't received any of that information from Travis County. As far as I know, Philip, who's assigned the case, hasn't received that either.
I forwarded him the order earlier when he was in here. I can forward it to you as well. He said he was going to just make contact with Travis County so they can see what their process is going to be.
So is he down working on trial?
Yes, Judge.
Okay. Okay, will you get that to Ms. Buse and,
Yes.
and talk to her and you, so I can get the state's position on it?
Will do.
And then, I mean, I'm happy, I understand the issues that you're.
Actually, ironically, you may be best off talking to Molly.
That's what
over
Philip
there.
said, but
She's our mental health expert.
really, we just need to, we're just kind of in the way of starting his treatment. That
Okay.
warrant is preventing him from going to the mental health facility. Not necessarily that we need to do anything with his case right now, just so long as that's lingering out there, he can't move to that bed.
So if there's a request or whatever it is, I don't have it in front of me other than what you're saying. You said you sent it to Philip. What I'm asking you to do is if you would speak to the state so that I can get their position on it, right?
Sounds good, Judge.
Just forward it to
I'm
Molly.
not saying no.
You've done this earlier, Molly. I asked you if you could help me.
Okay. All right, we got people coming up?
Yes, sir.
All right, very good. Hello, how are you? No, we got it. We can start it. You ready, Ruby?
Mr. Shearer, and I'm sorry I did not look at the paper. Running back and forth more window.
All right. What other courts are you in?
I was in the 207 and it's cold in here and hot in there and that's not a good Combination for me running back and forth.
Hey, good, sir.
Yes, sir.
Ruby? Court call CR 23-3668F, the state of Texas versus John David Shearer. Can counsel please make their announcements for the record?
Allison Boost for the state.
Allison Tisdale for Mr. Shearer.
And are you the same John David Shearer who in CR 23-3668F is charged with continuous violence against the family?
Yes, sir.
That's a third-degree felony. State, what is the range of punishment for that charge?
Not less than 2 years, no more than 10 years in Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that's the range of punishment that you face for this charge?
Yes, sir.
Can you raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
I have in front of me paperwork that indicates you would like to enter into a plea bargaining agreement. I'm showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, Your Honor.
On page 4, there are a list of rights that you'd be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving these rights?
Yes, Your Honor.
On page 5, there is a stipulation of evidence. I will use that. Pardon me, it's on page 6 here. On page 6, I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes, Your Honor.
And is this your signature on the final page?
Yes, sir.
So this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow it, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, sir.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, sir.
Understanding them, do you still wish to proceed with this plea agreement?
I do, Your Honor.
Are you a citizen of the United States?
Yes, sir.
If not, a plea in a case like this could have serious consequences. Counsel, I have in front of me the discovery compliance statement regarding the state's duty to give you evidence pursuant to 3914 of the Code of Criminal Procedure. Are you satisfied the state fulfilled that obligation?
I am, Your Honor.
And do you believe that your client is competent to enter into this plea?
I do, Your Honor.
The reason we talk about the evidence is because you have the right to know what the evidence is against you in a case. Did you discuss that with your attorney?
Yes, sir.
And do you believe your attorney has provided you with effective assistance during the course of this case?
I do, Your Honor.
According to your plea bargain agreement, in exchange for your plea of guilty to continuous violence against the family, the state will recommend deferred adjudication. There will be a finding of family violence, a fine, fee, an evaluation, community service, and you will attend a parenting class and complete it, and you will have no harmful or harassing contact with Ms. Mendoza and Ms. Ishino?
Yes, Your Honor.
Ishino?
Yes, Your Honor.
Hoshino.
How do you, I just, it's
It's
not written
Hoshino.
very,
It's very different. Yes.
Okay.
Hoshino.
very good. You know who those people are.
Yes, Your Honor.
All right. And is that your understanding of the agreement?
Yes, sir.
Would you like to enter into that agreement now?
Yes, sir.
All right, let me let you know, deferred adjudication, what will happen is that I will order a PSI. That means that we will come back and do your sentencing at a future date. I will not be the person here, but the next judge who is here in 2025 will make the decision. If that person follows your plea bargain agreement, you will not have a right of appeal then either. Is that understood?
Yes, sir.
And you understand that there will be a new person that will be sitting here that will doing that.
I do.
I just want to give you notice. Also, you're asking for deferred adjudication. That's both a good and bad. Good in that if you complete everything successfully, could be better for your record. Bad in the sense that if you are, if you violate, you could be subject to the full range of punishment for a third-degree felony. Do you understand that?
Yes, sir.
Very good. To the charge of continuous violence against the family, how do you plead?
Plead guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
I need to add an honor about on that jury charge. Okay, based on your plea of guilty, based on the stipulation of evidence, I find that there is sufficient evidence to substantiate your guilt, but I don't find you guilty at this time. I'm going to order a PSI. That means someone from probation will come and talk to you. Make sure you cooperate with them. After they've prepared their report, we'll come back and the new judge will sentence you. Understood?
Yes, Your Honor.
All right, make sure you work with probation when they come to you.
I will.
All
Thank
right,
you, sir.
good luck to you, sir.
Thank you, Judge.
Yes, ma'am. Thank you. Good to see you.
Good to see you.
Hey, Mr. McCormack.
Good morning.
Who are you here on?
I have two cases. I have Mr. Alonso, Augustine Alonso. He just got out of jail fairly recently. I would ask for one more pretrial.
Is he here?
Yes.
Mr. Alonso, can you come on up, please? How you doing, sir?
Hi, Aaron.
We've talked before, haven't we?
Yes, sir.
I remember that. How you doing?
It's good.
Are you clean today?
Uh,
No. Okay. Can pretrial services please test him? Give us a few minutes to come back and we'll discuss.
Understood.
Are you going to be clean?
I used.
Okay. Fair enough. What'd you use?
Methadone.
Okay, is that it?
Yes, sir.
All right. Are you on pretrial services right now?
Yes,
He,
sir.
he is. He was supposed to go and report after
After
today's
today.
hearing.
It was about this.
How frequent, I mean, how recently did you use?
Week ago, last Wednesday.
Okay, well then if it was really last Wednesday, then it won't be in your system today. That means if it's gonna be in your system today, you more recently used. Do you want to let me know if you
Well, I
used,
used last Wednesday, also last,
but you also used when? Because if it comes up positive, I'm gonna know you've used since last Wednesday also.
it was last Wednesday when I used.
Okay, well then you're not gonna come up positive. All right, but let's go check that out. All right,
Yes, sir.
come back after you get done.
Okay.
The other case I have is a plea. We have the paperwork signed. He just needs to be sworn to, I think.
Right.
Oh, okay, okay.
Who is that?
Michael Effinaccio.
It's the co-defendant for Christopher Williams and Annalisa Blackman, and it will be an open plea with a 20-year cap.
Okay. So I will not make that decision. I will just take the plea today.
Understood.
Okay. And you're here on Middleton, is that right?
Judge Presenza, yes.
Okay. Coming up, let's get your client up. Did you talk to the state? Did you talk to the state on that?
I did.
And what's your position, state?
Judge, I don't see any issue with withdrawing the warrant. He is under an order to not release except for the state hospital.
Okay. That case name is?
Patrick Walters.
Walters. Have it. Thank you, state, for looking into that. Thank you for conferring with them.
What's the name on this one?
Effinaccio. Michael.
I made a note in the criminal docket to withdraw the warrant. Yes. All right, sir, how you doing?
I'm doing.
And Judge, this is another situation where the state has a oral motion to amend the indictment. I don't know if you want to do that before he takes the plea or as part of the plea, but
Very good. What are you proceeding on? The murder?
only on count 1, paragraph C.
And what is your motion going to be?
It's going to be amend the allegation from discharge to cause the discharge of.
You ready, Ruby?
Yes.
Court calls CR 20-5499E, the state of Texas versus Michael Tyreek Ifianacho. Can council please make their announcements for the record?
Allison Boost for the state.
Cliff McCormick for Mr. Effinaccio.
And are you the same, Michael Tyreek Ifianacho, who in CR 20-5499E is charged in count 1 with murder and count 2 with robbery?
Yes, sir.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, this murder charge is a first-degree felony. State, what is the range of punishment?
It's not less than 5 years, no more than 99 years or life in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that that is the range of punishment that you face for that charge?
Yes, sir.
For robbery, that is a second-degree felony. State, what's the range of punishment?
not less than 2 years, no more than 20 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that's the range of punishment that you face for that charge?
Yes, sir.
All right, state, you have a motion?
Yes, state has a motion to amend the indictment, specifically paragraph C of count 1.
That C or E?
C is in Charles.
Thank you.
And the state is specifically amending the language of paragraph C to now read, then and there commit or attempt to commit an act clearly dangerous to human life, namely cause the discharge of a firearm at or in the direction of Canberra Winters.
Defense, do you have any objection to that change?
No objection.
That also means that you have 10 days for which you could further prepare instead of entering to this plea agreement, or you can waive it.
We wish to waive that.
All right. Have you discussed with your attorney what that means, that you have the opportunity to take 10 more days to consider what the state just modified if you wanted to, or you can waive it? Your attorney says that he wants to waive it. Is that what you'd like to do as well?
Yes, sir.
All right. I have plea paperwork that indicates you would like to enter into a plea bargain agreement. I'm showing you the admonishments, the written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, sir.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, sir.
On page 6, there is a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes, sir.
And is this your signature on the final page?
Yeah.
Yes, sir.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, sir.
And you don't have to plead at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial, and you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, sir.
Understanding those rights, do you still wish to proceed with this plea agreement?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence in accordance with 3914 of the Code of Criminal Procedure. Are you satisfied that the state fulfilled that obligation?
To the best of my knowledge, I am satisfied.
And do you believe that your client is competent to enter into this plea today?
I believe he is, Your Honor.
The reason that we discuss the evidence, because you have the right to know what the evidence is against you in your case. Did you discuss that with your attorney?
Yes, sir.
And do you believe that your attorney is do you believe that your attorney has provided you with effective assistance during the course of this case?
Yes, sir.
All right. According to your plea bargain agreement, the state will waive count 2 and proceed only on count 1 for murder. In exchange for your plea guilty, there will be a plea bargain of no agreed recommendation. The state agrees to a cap of 20 years in the Texas Department of Criminal Justice in exchange for your plea of guilty. Is that your understanding of the agreement?
Yes, sir.
And would you like to enter into that agreement now?
Yes, sir.
What that means is that you will be subject between 5 and 20 years in the Texas Department of Criminal Justice. Do you understand that?
Yes, sir.
And I will not be the person who makes that decision. After today, if we move forward and you want to move forward, I will order a PSI. That means someone from probation will meet with you. You will talk to them. They will come back and give a summary of the case, of your background, and then the judge at that point will make the decision of what your sentence will be. That judge will not be me. There will be another judge here in 2025. Understand, though, that doesn't change anything here. If that judge follows this range that we've just discussed, you can't withdraw your plea. Do you understand that?
Yes, sir.
And I just want you to understand that it will not be me that makes the decision. You understand that as well?
Yes, sir.
Understanding all that, do you still wish to proceed with this plea agreement under these terms?
Yes, sir.
To the charge of murder, particularly paragraph C of count 1. How do you plead?
Guilty.
Are you pleading guilty because you are guilty for no other reason?
Yes, sir.
Is anyone forcing you to take this plea?
No, sir.
Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt. Will he be applying for deferred adjudication?
He will.
In that case, I will not make a decision as to your guilt, only that there is sufficient evidence to substantiate your guilt. Someone from, I order a PSI, someone from probation will talk to you, make sure you cooperate. We'll come back, well, y'all will come back and do your sentencing at a future date. All right?
Okay.
Any questions?
No, sir.
Very good. Good luck to you, sir.
Thank you, Judge.
Thank you. You. Hello, Mr. Evans.
Afternoon, how are you? Good morning, Judge. Sorry about that. How are you doing?
Good. How are you?
All right. I'm thinking. Judge. Had a different case. If there was a revocation hearing later, would they be capped at 20 at that point?
That is an interesting question.
I think that they would be.
Yeah, I think so too. Right.
It's the same as.
Yeah.
Yeah, I mean,
Yeah.
well, you're gonna be, yeah.
Yeah, it's just a question I was thinking about when.
No, it's a good
When you
question.
mentioned,
I
when
like
you
it.
mentioned that to me, I was like, man.
Yeah.
Huh.
All right, you're here on.
Here, Mr. Middleton.
Middleton? All right, are we
Did-
ready?
We are, Judge.
Have you had the opportunity to review the PSI?
I sure did.
Okay. Mr. Middleton, can you approach, please?
And he went down and tested with the probation department. He's clean.
Clean today. Good. Ruby, are you ready? Good morning. You always make me jealous with all that hair.
Yeah.
Court calls CR 23-4854F, the state of Texas versus Joseph Aloysius Middleton. How do you say that middle name?
Aloysius.
Aloysius?
Aloysius.
Aloysius. Where does that come from?
It's Italian.
Okay, very good. Is that you? Are you Joseph Aloysius Middleton?
I am.
All right. And are you the same one who was charged in CR 23-4854F with possession of a controlled substance, cocaine, 1 to 4 grams?
Yes, Your Honor.
Can you raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. State and counsel for both sides, can you make your introductions for the record?
Allison Boost for the state.
John Evans from Mr. Middleton.
We're here today for your sentencing. I have received a pre-sentence investigation report from probation. Counsel, have you had the opportunity to review this report and discuss it with your client?
I have, Your Honor.
Are there any modifications or corrections?
They're not, Your Honor.
Is there any legal reason we can't proceed to sentencing?
There's not, Judge.
Any argument from the state?
No, Your Honor.
Argument from defense?
No, Your Honor.
Having found that there was sufficient evidence to substantiate your guilt, I did not previously find you guilty, and now I will grant your application for deferred adjudication. That will be for 3 years. There will be a $500 fine, court costs, those are due today. You will pay restitution and do 200 hours of community service. In addition, as far as the programs, you will do the intensive outpatient supportive aftercare. You will pay outstanding restitution. State, do you know how much that is?
The outstanding restitution amount is $288.
All right, you'll be ordered to pay. You will do the mutual support group. That is an NA or AA class. I want you to do that at least 3 times per week. All right, I know that's a lot, but the reason that we do 3 is because the evidence shows that 3 times a week is what makes you most
That's effective.
successful.
Yeah.
One of the very best programs. Have you been doing any of that? So
Yes, sir.
Is it working?
Yes.
I mean,
Yeah.
it's helping.
Yes.
I mean,
Yeah, I've
working
been
is,
sober.
it's an ongoing thing, right? So
Mhm.
it's helping. Good. I hope so. I think it's a great program. We know it's just one of the best. Make sure that you're providing proof of attendance to the probation office. You'll do the moral recognition therapy class and the counseling that you are doing. You will continue with that counseling. Understood?
Yes.
A little worried, seeing what I read in here, mixing the prescriptions that you have, because I know you, when you're testing, it's showing some of those prescriptions as something else, but mixing that with, right? I mean, it shows up
He takes
as,
some prescription drugs, just.
Yeah.
Judges.
and so those show up, with some things that, like, it looks like amphetamines and, benzodiazepines, right?
Those are what I'm.
Yeah, so you need to
prescribed.
take those. My concern is when you're mixing those with cocaine, right?
Oh, well, yeah.
Yeah, and
I'm
so
not.
that's not going to, whatever those are, I want you to take the drugs and that's not a problem here. It's just, let's not mix those.
Yeah, I haven't in anything.
Awesome.
Or
Well, then,
since I was caught.
great. Well, let's get on those NAs and AAs. I think that will be helpful too along the way. Is there anything else that we need to take up?
Nothing from the state.
Judge, the only matter is he does live in Bear County, so I'm assuming probation will be transferred to Bear County at some point.
Very good.
Very good.
Sir, I followed your plea bargain agreement. Because I've followed your agreement, you do not have a right of appeal. I've signed the trial court certification that will be added to your file. Good luck to you, sir.
Thank you.
Thank you, Judge. Maybe excuse.
Mr.
You may.
Wilson, borrow your right thumb real quick, straight up, straight down on the pad, and then straight up, straight down in the box. You don't need to roll,
Oh.
just straight up, straight down.
Got it.
There you go. Don't get that on your suit.
Thank you.
That one.
That's it.
I would hate for us to move forward in a short time here to be on. What was his name? Thank you.
And Judge, you missed the rare opportunity that you had three Allisons at the bench.
Allison, who was the
Allison Tisdale, and Allison
Oh.
Saylor.
slipping? Okay, is your client up?
Yes, Judge, he's the one that's in custody.
Come on up, sir.
He's primarily a Spanish
Name?
speaker. He does understand English. If you need some translation, I can help the court.
Name?
Enzo Fernandez Morales.
Fernandez Morales. Good morning.
Good morning.
Oh, okay. So we have a translator if you need one.
We have one? Oh, yeah, ma'am, can we get you to come up and translate for us? Thank you.
Thanks for something.
Sir, if you just step back just a step so that she can speak to you. Okay, we're here today on a pre-trial setting for you. Your attorney has been in here working on your behalf and conferring with the state. We bring you up to let you know what's going on in your case. Counsel, do you have discovery in this case?
I do, Judge.
Do you have an offer in this case?
Yes. Just to give the court a heads up, we were just gonna ask for another reset, a different case surfaced down in Bear County. If that actually gets filed, that'll expedite our finishing here. If it doesn't, then we might decide whether or not we're gonna go to trial. We still need to, we're kind of waiting and we're kind of stuck in between two things, Judge. if we're being
Okay.
honest.
All right, so the only thing that I'm thinking is that we need to start moving this forward. Do you know the timeline in Bear County?
I'm not too sure. I was contacted by officer and someone from the court. It's a first degree down there. Still waiting for the indictment.
What's the charge?
Aggravated assault with a deadly weapon.
Is this part of
No, completely separate.
train de aragua activities?
From what I understand, from what they told me, it's completely separate. It's just an isolated incident.
Okay. So what we'll do, given the amount of time that he's been in custody, we're going to put this at a plea setting. It does not mean that you have to plea.
May I offer a Kleenex to
Yes.
the defendant?
Thanks. We're going to move this to a plea setting. That does not mean that you have to plead, but if there is not some sort of resolution, the next setting after that would be a trial setting. Is there anything else we need to take up?
No, yeah, that's
All
all.
right, thank you for your patience. All right, so you understand what's going on?
Entiende lo que está sucediendo.
Very good. All right.
Thank you, Judge.
Yes, sir. Thank you.
You're welcome. Thank you.
Thank you. What's going on?
Well, they presented me with what they want me to sign, which is sex offender treatment. This is what they have proposed. The court is ordering.
So I want it to say whatever it says on that form, right? Counseling,
Specifically,
she said, it says in there. Hold on, I'm with you. I'm with you. But what does her language say?
Benefit from mental health counseling and some individual counseling regarding healthy sexual behavior.
Okay, so is she going to provide that? Michaela, come up. I want you to hear.
And
Yes, sir. Her office is the therapist that provides this.
Okay,
And so this condition says to get the evaluation, which has been done, and get the treatment as recommended.
well, that is the sex offender treatment language, is what that is.
If I may.
just one second. I want to read what it says. Is she? No, I know I just asked this, but let's be clear. Is this counselor, the doctor that made that recommendation, is she going to be providing the counseling?
Yes.
Okay, so can we say, and counseling under the supervision of, and name that doctor?
So she has therapists under her. So if we could just put Shoal Creek Counseling.
Okay, any problem with that?
Well, no, the objection I have is this is the sex offender treatment conditions as stated in there. That's not what's been recommended or ordered, period.
So,
I mean, it just hasn't.
okay, so let's go through it then.
If I may.
Yeah.
The court has already ordered, as part of his terms and conditions of probation, a separate cognitive track and counseling and treatment, separate and apart from this already, which, in my opinion, would cover what she's recommending. However, I have no objection to specific language that incorporates what she's recommending. And in specific language, it would say, Mr. Mikhailovich shall undergo individual counseling by Shoal Creek Associates regarding healthy sexual behavior. I have no problem with it as they recommend. I have no problem.
That's what I'm trying to get to. I'm with you.
I understand.
That's why I want to submit to and actively participate in a specialized sex offender evaluation. He did that.
We've already done it.
Okay. So we're just going to mark it out because we don't even have to, right? Everyone okay with that? Doesn't matter. We're going to mark it out. Submit to counseling under the supervision of Shoal Creek. Tell me the name, please.
Shoal Creek Associates.
Shoal Creek Counseling.
Shoal Creek Counseling. As approved and directed by your, doesn't need, we're saying who it is. You must comply with all therapy rules, regulations, and restrictions, pay all costs, attend all therapy sessions, participate in all the programs, everything that they have, and ensure that written verification of attendance and programs are provided monthly to community supervision officer until successfully discharged by the Shoal Creek Counseling.
You can just say by provider.
By provider and released from this condition by the court.
And I would just somehow incorporate language that incorporates what they recommend. Is counseling related to
Okay,
healthy
regarding
sexual
what?
behavior?
What does he say?
It's the last line of the report.
Mr. Michaelowicz, do you understand that you must submit to Shoal Creek Counseling regarding healthy sexual behavior? It will be, you must comply with all their rules, regulations, and everything else there, the counseling that is required. And you must provide verification of your attendance and progress monthly to your community supervision officer until you are successfully discharged by that provider and released from this condition by the court. You understand that?
Yes.
Okay, it's the order of the court.
Thank you, Judge.
Thank you.
Appreciate it.
Your signature.
How you doing? Good. Who are you here with?
I have a plea on Matthew Moody.
Moody?
Yes, he's the inmate.
Come on up, Mr. Moody. Taking a plea here?
Yes, correct, sir.
Going to sentence today?
Yes, sir.
Very good. Ruby, are you ready?
Yes.
Court calls CR 24-2916F, the state of Texas versus Matthew Joel Moody. Can counsel please make their announcements for the record?
Allison Booth for the state.
Carlos Ramirez for Mr. Moody.
And are you the same Matthew Joel Moody, who in CR 24-2916F is charged with, in count 1, aggravated assault with a deadly weapon, and count 2, unlawful possession of a firearm by a felon?
Yes.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Count 1, the aggravated assault, is a second-degree felony. State, what is the range of punishment?
It's not less than 2 years, no more than 20 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that is the range of punishment that you face for that charge?
Yes, Your Honor.
Count 2 is a third-degree felony. State, what is the range of punishment?
Not less than 2 years, no more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that is the range of punishment for that charge?
Yes, Your Honor.
I have paperwork here that indicates you would like to enter into a plea bargain agreement. I'm showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, Your Honor.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, Your Honor.
On page 5, there's a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes, Your Honor.
And on page 6, is that your signature?
Yes, Your Honor.
The final page of the document. Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, Your Honor.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, Your Honor.
Understanding them, do you wish to proceed with this plea agreement?
Yes.
Are you a citizen of the United States?
Yes, sir.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence in accordance with Article 3914 of the Code of Criminal Procedure. Are you satisfied the state fulfilled that obligation?
Yes, I am satisfied, Your Honor.
And do you believe that Mr. Moody is competent to enter into this plea?
Yes, Your Honor.
Mr. Moody, the reason we talk about the evidence is because you have the right to know what the evidence is against you in your case. Did you discuss that evidence with your attorney?
Yes.
And do you believe your attorney has provided you with effective assistance during the course of your case?
Yes, Your Honor.
According to your plea bargain agreement, in exchange to your plea of guilty in counts 1 and count 2, the state will recommend 2 years in the Texas Department of Criminal Justice. You will get credit for the time that you have served, and there will be affirmative finding that a deadly weapon was used. Is that your understanding of the agreement?
Yes, Your Honor.
Would you like to enter into that agreement now?
Yes, Your Honor.
To the charge of aggravated assault with a deadly weapon, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
To the charge of unlawful possession of a firearm by a felon, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
State, have you given notice to the victims in these cases of the proposed resolution?
No, Your Honor, we've been unable to, as the defendant has his own pending charge being prosecuted by our office that's currently outstanding related to the same offense. So we're conflicted from contacting him. We will, however, notify his attorney.
Okay. Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt. One of the things that I have your waiver of arraignment from today, you have 10 days from today that you could put this off to consider the plea bargain agreement, or you could waive it. Have you talked to your attorney about that?
Yes,
And what have you decided to do?
decided to waive it.
All right, that is your decision?
Yes, sir.
Very good. Having found that there was sufficient evidence, I now found you guilty of aggravated assault with a deadly weapon and unlawful possession of a firearm by a felon. Is there any legal reason we can't proceed to sentencing at this time?
Nothing for the state.
That's from defense.
Having found you guilty in counts 1 and count 2, the court now sentences you to 2 years in the Texas Department of Criminal Justice. You will get the credit for the time that you have served. There will be a finding that a deadly weapon was used. Is there anything else we need to take up?
Nothing from the state.
From defense.
Mr. Moody, I followed your plea bargain agreement. Because I have followed your agreement, you do not have a right of appeal, and I am signing the trial court certification. That will be added to your file. Good luck to you, sir.
Oh, Mr. Moody, real quick.
Okay.
Need to borrow your right thumb, please. Straight up, straight down,
Oh,
and then straight up, straight down in the box.
quick.
And then same thing again. There you go.
Thank you.
Thank you.
Oh, the judgment?
Yeah.
Yeah. You signed that.
Yes, but it was on which case?
Middleton.
Yes, and so I just wanted to make sure I didn't.
Oh, no.
I didn't want to cause you
No.
problems.
Thank you.
My, yes.
Hey, Judge, I have a case on Mr. Philip Moreno,
Moreno.
and Mr. Moreno is present. This is prosecutor.
Ms. Moreno, come on up, please.
Prosecutor Philip is not present today. He sent him a good guy packet on Philip Moreno. And he hasn't had a chance to go through that yet. So we're just asking for that reason for a reset.
Okay, when did you send it to him?
It's been a couple weeks at least,
All right.
but I know he's understanding he's preparing for a trial or something along those lines.
State, what's your position?
Judge, I'll double check and make sure that that gets looked at. That shouldn't have taken time. Let me
Okay.
see.
Yeah, that's surprising to me. We're gonna, that's fine. You'll have time.
Okay.
We're moving it to a trial setting.
We'll get.
But
I'll
that
catch
means
up
so the
with
next
you.
time you come back here, you'll be for trial. If there is a resolution before then, I'll be happy to take it, or the next person sitting here can before your trial begins.
Okay.
All right, thank you very much. Yes, sir.
I'm back on Mr. Alonso. We got tested.
Alonso, Mr. Alonso, come on up. Pretrial services, do you have his results, please? Can you bring me the form, please? Okay. I'm gonna keep this. Okay, I'm gonna keep this.
Thank you.
All right, Mr. Alonso, we've had this issue come up before, haven't we?
This is the first time he's been tested. Judge, he's willing to do any kind of treatment now before this case gets resolved, if the court were to consider that for pretrial services, whether it's inpatient or outpatient.
Pretrial services, is there a program that you would recommend for Mr. Alonso? First, though, we need to talk before we get into it. If you really want help, you've got to, be honest about your situation. And having used 6 days ago, meth doesn't stay in your system for 6 days. When was the last time you used?
Last Wednesday.
Huh?
It was last Wednesday.
Yeah, so it's not going to show up, right?
It shouldn't.
It shouldn't. It's 3 to 4 days is typical.
Yeah,
Is my
4's on the
understanding.
long end.
I'm sorry, the officer that was guiding me to the register, he said it was barely getting out of my system.
What's that?
It was barely getting out of my system. That's what the officer had told me when he.
But we're talking now 6 days. It's just not.
That's
Did you
the last-
use over the weekend?
No, sir.
Okay. I think you did. Because that's 3 days. And it's just, look, all the data tells us that. So we have to do something. State, what is your position?
Judge State's position is that he's violated his bond and poses a danger to himself and the community by continuing to use methamphetamine.
And what are you asking for?
I would ask that his bond be raised.
Okay, I understand they're asking for your bond to be raised and you be taken into custody today. What are other options that pretrial services would recommend?
I mean, we can increase drug testing. We could do weekly drug testing. We could try to get him into IOP, something like that.
Okay, well, is there an intensive, some sort of program that you can get him into?
We could try. It just depends on insurance and things like that. But we have Texas Icon that we work with, so we could get in touch with them, get a referral with him, and they could work with him to see what's available to him. It just really depends on insurance and things like that.
And he's under your supervision right now?
Correct, yes, sir.
When was the last time he was tested?
I only received him on about a month ago, so I had scheduled him today to come in for a drug testing, so he had not come in prior.
What kind of testing is he on?
Urine analysis.
Right, but is it just any, or is it frequent random?
It wasn't frequent random, it was just whenever, yeah, so frequent random.
It was not, or it was?
It was, I'm sorry, yes, sir.
Okay, well, frequent random needs to be more than once a month.
Okay. Right.
So at least weekly.
Right.
All right, and surprisingly.
Yes, sir.
All right. All right, so you understand what the state's asking for. Your attorney is saying, put you in a program. What do you want to do? And I mean, not what do you want to do? I'm not asking what you think is going to be easiest for you. I'm asking what you see as your path forward right now.
Okay, I would like to join these programs that are offered towards me.
Okay.
I do.
Why?
Yeah.
What has changed since the last time you used meth? Within the last 3 days, or as you would say, 6 days ago. What has changed in that time that makes you serious about getting into a program other than you're up here at the bench right now and you know that the state is suggesting, and I think they're with good reason, that you should be taken into custody today. What's changed? You don't want to go to jail today.
No, sir, I don't.
You have a job?
At the moment, I'm currently getting my social security card, getting my valid ID license, my ID card. And out there looking for a job, also being helped. And being I don't know if this excuse, but being a diabetic too is not helping. I need medicine. I need.
That's right. Well, but being a diabetic is not helping to be doing
Correct.
meth.
Correct.
Right.
The only thing, Judge, I would say is that this is the first time he's tested. He has been out a month. Is to give him.
Been out of what?
Custody for a
Okay.
month. And so I
Did-
know,
did I
I know he
change it?
tested. Huh?
Did I change it to a PR bond?
Yes, you did. The state was not opposed to that.
I changed it. I
Mhm.
kind of remember this now. Was there
Yes.
like some $75,000 bond on him?
No, I don't think it was that high.
You
But
had
it was,
another guy though that had a $75,000.
I probably did, any guys.
Yeah. But we came in and we
I
had
don't.
this, and we reduced the bond.
We reduced the bond, but Judge, I'm just saying that since this is the first time he's tested positive, get him into a program, test him weekly. If he tests positive again.
I mean, that's what we said the last time.
I know,
When you
but
said-
he
when you-
wasn't
When you said give him a PR bond in the first place.
understood, Judge, but he was in jail and he hadn't been tested. Yeah, so that's all I'm saying. It's the
Right.
first test.
Right.
That's all.
Well, but the whole, I mean, I'm not arguing with you. I'm just saying like that was what he came and said on your behalf last time
Right.
was if you let him out of jail, he's not going to be doing methamphetamines. And then on the very first test, which
Yeah.
was a month later, which we're going to do better there, is you're testing positive. So there have to be consequences for that. I want pretrial services. They're already doing supervision. Please begin to look for a program for him. In the meantime, the bond will be a $2,000 cash surety bond, and the $10,000 PR bond will be a $5,000 cash surety bond. Understood? All right. So they're going to take you into custody today. All right.
No.
I want you to get out, and do better, but there have to be consequences when you got out, because you stood up here and I remember
Yes, I understand.
and said, I'm not going to do it again. Let me out on a PR bond. And I went with you, right? I gave you the benefit of the doubt.
You did.
All right. All right. Well, I want you to do well.
All right.
Good luck to you.
Thank you, Judge.
Thank you.
Mhm. Hey, Judge, I can reset that to pretrial, correct?
Do you have an offer?
I have not discussed the case with you.
Okay. Well, before we reset it today, let's get an offer.
Okay.
Okay. State, can you provide an offer?
Yes, sir.
Do you have discovery?
Yes.
He needs to get into a program of some sort, or this case needs to go away. Let's move it. We're going to move it to a plea setting. Sir, it does not mean that you have to plea, but if there is no agreement, then the setting after that would be a trial setting. All right. Thank you. How you doing, Mr. Daniels?
Good, Your Honor.
Good. Who you got?
I'm a pretrial docket.
Yes, sir.
Felicia Martinez is not here, but I can't say for sure that she had this court date. I get no responses to the email address. I have a phone number for an intermediary that has a voicemail greeting. I have a phone number that nobody answers, but it does take messages. The good news is that the surety tells me she checked in with them through their app over the weekend, but because it was the weekend, she didn't speak to anybody. It's for them to tell her about today's court date.
Okay.
Would it be possible to have another pretrial setting and no bond forfeiture?
If she turns herself in by 9 o'clock tomorrow morning, we won't forfeit her bond. So I'll give her 24 hours to show up. You can be in touch with her. That gives her a chance. Maybe there was a mistake today, but she's also on for methamphetamine, and this is not a good sign.
Thank you.
Okay. What is her bond?
Felicia Martinez.
Oh, Ashley. Okay, so she needs to come to court tomorrow and make sure that she has contact by 9:30 with the bailiff. Okay? How much? Okay, it'll be 7,500. Yeah, sure. Give her until 9:30 tomorrow morning. Yes, yes.
This is on behalf of Rolando Solis, the urinalysis test.
Mr. Solis, come on up.
Your defense mistakenly sent him down to adult probation instead of pretrial services. The defense doesn't.
All right. Well, you admitted that that was going to happen. I think that's a good thing. So you understand that you cannot use drugs
Yes, sir.
while you were on bond.
Yes, sir.
Okay.
I apologize for lying to you in the court.
And what's that?
I apologize for lying to you in the court, Your Honor.
Well, I think you came back and did better. And so I appreciate that, right? Now, what are we going to do so that it doesn't happen again? Because now there has to be some sort of consequences.
I can do a drug test.
You're going to do drug tests?
Weekly or monthly.
Yeah.
However you want.
Well, I'm sorry, this is a. Give that file. Do you have discovery on this case?
Yes, Your Honor. And we have reviewed discovery together.
Do you have an offer?
We received an offer this morning, yes, Your Honor. We are working on mitigation at this time.
So you understand that what he's saying when he's working on mitigation, they want to show that you're doing things right. Testing positive isn't good. What I'm going to do is add frequent random UAs. Okay. You said, when was the last time you used?
Like to be honest.
When?
I believe.
What was the event so that we can go back in time and remember? Were you hanging out with buddies? Were you watching football?
Buddies.
Okay. Okay. So 2 weeks ago was the last time.
Like on the 5th. I believe.
On the 5th? Okay. So by, it stays in your system for 30 days. That's really the last time you used. By December 5th, it's going to be out of your system.
Okay.
So we're going to come back at our next criminal docket in December, and you will have been tested several times between now and then. And by that next setting, it will be outside of 30 days and you should be clean. All right. If you're not, then we will look at what the next consequence will be. You understand how it works now?
Yes, sir.
Okay, very good. We'll do the right thing. All right. We'll set it for another pre-trial setting at the criminal docket in December.
Thank you very much.
Thank you. All right. Pre-trial services, will y'all test him, please, frequently and randomly? How you doing, Mr. Green?
Good. How about you, Judge?
Good.
Can I approach?
Yes. Who are you here on?
2 cases this morning, Judge. First is Timothy Enholt with the EHM.
Mr. Enholt? Oh, he's here.
He is, Judge.
All right. We had increased the bond because I didn't know you were here.
Yeah, I know.
What's that?
I came in just in the middle of the docket. I think I came in on G.
Okay, why were you late?
I just, I came in 2.5 hours from Houston, so just a little bit longer ride than expected.
Okay, well, 10:30 means you're left, not to ever make it in time, even if there's like a little.
No. What do you mean by 2:30?
What time did you get here?
I got here while you were doing docket call at like 9 o'clock.
Oh, you did?
9:04, yeah.
Oh, okay.
You were on G.
Oh, well, I appreciate that.
No problem. I told the bailiff.
Okay, very good. I appreciate that. That is a long drive. All right, so we're here today because defense had asked for a plea setting. Is there any resolution in this case?
There has not been, Judge. We're going to request that this be put on the trial docket.
Okay, we'll move it to a trial setting. Very good. And you do have an offer on this case?
Oh, we do, Judge. It's been relayed to my client, and we respectfully refuse the offer.
No problem. All right, well then we'll come back next time on a trial.
Thank you, Ron.
Thank
We'll
you.
get you received.
Thank you, Ashley.
Is that this?
It is, that's it. Now, one more, Judge, of Robin Medina.
Medina?
Yes, sir. And are we on the record right now? Is there any way?
We're not on the record, but we are on live stream.
Okay.
Is that what you're concerned with?
That is what I'm concerned about, Judge. That's a little bit embarrassing for the client. If you don't mind, to be pause that or something.
Yes.
Thank you, Judge.
I'll come talk to you in a minute. What do you have?
Real quick, pre-trial. They wanted to know whether or not he's going to be assigned to the pre-trial and whether or not they needed to be a pre-trial condition.
For Solis?
For Mr. Solis.
I mean, the minimum that. Oh, this one.
I've not met him.
Okay. For a pretrial, do your standard observation and help for Mr. Solis, but I'm not looking for the full thing. I just want to make sure that he's frequently and randomly tested. Okay?
The same with Kim Blood?
Yes, but you can do the full range of PTS services for her. Okay?
Thank you very much, Your Honor.
Yep. All right, we ready? Ruby, are you ready?
Yes.
How are your fingers today? We're moving. Court calls CR 24-1620F, State of Texas versus Ranulfo Torres Padron. Can you step back just so that it's not coming in here? ¿Qué pasa más allá? Okay, can council make their announcements for the record?
Allison Booth for the state.
Edwin Matiz for the fence, we're ready.
And are you the same Ranulfo Torres Padron, who in CR 24-1620F is charged with driving while intoxicated, third or more?
Yes.
Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. I need you to answer yes or no.
Yes, yes.
Yes.
And you have an interpreter here today. Ma'am, can you please raise your right hand? Do you promise or swear to give true interpretation of the events today?
I do, and for the record, my name is Sofia Leon, my license number is 192.
All right, this is a third-degree felony. That means that the range of punishment is between 2 years and 10 years in the Texas Department of Criminal Justice and a fine up to $10,000. Did you know that that is the range of punishment that you face for this charge?
No, I didn't know.
Okay, step back and talk to your attorney. We're off the record.
Yo te dije la sentencia mínima y la sentencia máxima. ¿Entiendes? Te dije que es.
Okay, we're back on the record. This charge is a third-degree felony. That means that the range of punishment is between 2 years and 10 years in the Texas Department of Criminal Justice and up to a $10,000 fine. Are you aware that that is the maximum and minimum punishment that is allowed for this charge?
Yes.
Your Honor, if I may, I think this charge is being enhanced to a second-degree felony.
Okay. I need you to understand that a third-degree felony as charged is 2 years to 10 years in the Texas Department of Criminal Justice. Do you understand that?
Yes.
As indicted, a third degree with an enhancement paragraph means that the range of punishment that you face is 2 years to 20 years in the Texas Department of Criminal Justice. Is that right, State?
That is correct.
Do you understand that that's what you face with the enhancement paragraph?
Yes.
Yes.
I have before me paperwork that indicates you would like to enter into a plea bargain agreement. I'm showing you the written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes.
Yes.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you would be waiving those rights?
Yes.
On page 6, there is a stipulation of evidence. Excuse me, it's on page 5. Are you proceeding with the enhancement paragraph, State?
We are, Your Honor.
It's not in the steps.
There were.
On the page,
The
let me just
original
finish with
issue.
him. On stipulation 5, there is a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes.
Okay, he'll step back and get the paperwork.
Yes, there was some confusion with the paperwork, and I informed them that it did not have the enhancement.
Okay.
So
Well, you can offer evidence if you want.
Judge, I believe you can read the enhancement paragraph from the indictment and have a plea to it. The paperwork indicates that he is pleading true to that enhancement paragraph, and if he enters that plea before the court, we should be fine.
and all of that has
Okay,
been
just bring it up.
It was all explained to him that he is pleading to an enhanced.
But
We will make an
if
effort
there's not a
to,
stipulation, then I have no evidence except for his. So I would be more than happy, which I'm not trying to do right now, to ask for evidence, which I would guess you will not provide.
we can print the certified judgment for you. That's not a problem.
They have provided that evidence.
Okay,
to the
well then
state.
let's do that. Is this your signature on the final page of this paperwork?
Yes, it is.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right for your attorney to cross-examine any witnesses that the state brings against you.
But I decided I'm gonna plead guilty.
Okay, very good. Do you understand all of those rights that I just named?
¿Entendió todos los derechos que le dije? Yes.
And understanding those rights, you wish to proceed with this plea agreement?
Yeah. Culpable.
Understanding the rights that I have named for you. You understand those rights that I just named?
¿Entiende esos derechos que le acabo de decir?
And,
Yes.
and understanding them, do you still wish to proceed with the plea agreement?
Acuerdo de la sentencia judicial.
Ya veo. Ya firmé.
I signed and everything is fine.
La pregunta es si quiere seguir con el acuerdo que se negoció. ¿Quiere este acuerdo?
Cierto acuerdo.
Yes, this agreement.
I went through your constitutional rights. You understand that you have those rights?
Yes.
Knowing that you have those rights, do you still wish to proceed with this plea agreement?
Ya negocié.
Yes, I already negotiated.
Okay. You want to go forward with this plea agreement.
Quiere proceder con esta sentencia negociada.
You want to do what is in this packet.
Quiere hacer lo que dice este paquete de documentos. Yes.
Are you a citizen of the United States?
Ciudadano de los Estados Unidos? Yes.
If not, a plea in a case like this could have serious consequences. Counsel, do you believe that your client is competent to enter into this plea today?
I do, Your Honor, and I just want to represent to the court that his options and his rights were explained very slowly, sometimes reacting, because I wanted to make sure that he
Hold on, sometimes what? There's so much-
sometimes I play act, you know, I say, okay, this is you here, this is, so he could understand exactly what he is waiving. Yeah, I went from one wall in the cell to the other, say, okay, this is you here, this is. I was a fifth grade school teacher, so.
Okay. I have before me the discovery compliance statement regarding the state's duty to give you evidence in accordance with Article 3914 of the Code of Criminal Procedure. Are you satisfied the state fulfilled that obligation?
Yeah, I've seen that.
Mr. Matias,
Yes, Your Honor.
I have before me the discovery compliance statement regarding the state's duty to give you evidence in accordance with Article 3914 of the Code of Criminal Procedure. Are you satisfied the state fulfilled that obligation?
Yes, I am.
The reason we talk about the evidence, sir, is because you have the right to know the evidence against you. Did you discuss that evidence with your attorney?
Yes, I did.
And do you believe your attorney has provided you with effective assistance of counsel during the course of this case?
Yes, yes.
According to your plea bargain agreement, in exchange for your plea of guilty to driving while intoxicated, third or more, with an enhancement, the state has agreed to an open plea with you. There are no agreed recommendations and you have no agreements with the state. Is that your understanding of this plea bargain agreement?
Yes.
And would you like to enter into that agreement now?
Yes.
To the charge of driving while intoxicated, third or more, how do you plead?
Guilty.
To the enhancement paragraph that on the 9th day of March 2009 in cause number CR 07619 in the 22nd District Court of Hays County, Texas, you were finally convicted of the felony offense of failure to stop and render aid, injury, or death. To that enhancement paragraph, how do you plead? True or not true?
True.
Are you pleading true because it is true and for no other reason?
Yes.
Are you pleading guilty to the underlying charge because you are guilty and for no other reason?
Yes.
State, do you have any evidence to offer?
Yes, Your Honor. State would offer what's been marked as State's Exhibit number 1, which is a copy of the certified documents regarding that previous conviction.
No objections, Your Honor.
State's Exhibit 1 is admitted. Based on your plea of guilty based on the stipulation of evidence and states Exhibit 1. The court finds that there is sufficient evidence to substantiate your guilt. Find that the enhancement paragraphs are true. What I'm going to do is order a PSI. That means the probation office will talk to you. They will prepare a report. After they have prepared a report, we'll come back and another judge will do your sentencing at that time. Do you understand that I will not be the person who sentences you, but rather another judge? And if that judge pronounces a sentence that is consistent with this plea bargain agreement, you will not have the right of appeal.
Okay, yes.
Very good. Have a good day, sir.
Igualmente, buena suerte. Venga, la próxima fecha, la próxima audiencia. Yes, I'm ready.
Did we get you everything on all of them?
Go ahead.
Okay. Because like,
I'll stay on it. And I'll just wait until you come back if we need to put anything on the record.
Okay.
But go ahead.
We've got a couple of hearings, huh?
Yes.
Yeah. Who are we taking a break?
No, but you can if you need one. You've got Molly Hill. Hello, Miss Brown. What are you here on?
Mr. Bernados.
On who?
Bernados and Merca, they're both in custody.
Great.
Yeah, so I don't know if you want to bring them up.
Thanks for
or-
joining us today.
I had like so many jail cases over in Caldwell.
In Caldwell.
Yeah, I had like 4 or 6 in jail.
All right. Well, can we get those people up?
So he's already got a couple and he's waiting for them to go down and then he's bringing Mr. Matthias and clients up for a reset.
Okay.
And then we also have 2 bond hearings.
Okay. Great.
We're just waiting for paperwork.
I had the other 2 commissioners, he's already coming to.
Okay.
Do you want me to just go to those right as really quick and come back or what? I'm
Well,
out here.
we're starting trial at 1, so I'd rather.
Well, I haven't seen Granada.
What are we doing on Granados? What are we doing? What are we doing on Granados?
I talked with Doc Morrow. I don't know if they told you, he put a bag over his head during his interview to try to suffocate himself, but she says he's fainting. She gave me a preliminary on it, but I don't think we've seen the physical report yet. But when it comes back out, I'll be good to deal and do it. So,
Okay.
but not today. I mean, I haven't seen the report yet, but she did call me, and told me what's going on during the interview.
Okay.
And then on Mr. Merca, he's set for a plea, but literally it's been in trial since I saw you. Like, so they all just got foiled, but it was for hearing. So I'd rather just reset Mr. Merca if we can. Renatus is feigning. According to Dr. Maurer, he put a bag over his head during his interview and tried to suffocate himself. So she had to cease the interview, which she called me. So we're anticipating a report that's going to say he's competent. I think she was working on insanity at the time of the offense.
What were we doing today with him?
It was a status, is all you call it.
Okay.
So can we just reset him? I think we have a set.
Well, I
don't
gotta
we?
get him up, so stay for. I'll just tell him.
Well, he's crazy though.
And Marco, we have to, what's that?
He's crazy though.
It's not.
He's a little organic guy.
No, I know he is. He's gonna have.
And then Marco was
Bark.
set for a plea guilty, but we're not ready to do that. I mean, I don't know if you want to move to jury or leave me another plea setting, because I still want to continue to work with the state. I mean, I think we're gonna end up working out. I don't want them to have to go into jury gear, issue subpoenas and all this kind of crap, because it's really not where it's going. But my client needs to have his hand held a little bit longer, and I haven't been over to jail to do that.
Yeah, we're gonna move his on to a trial setting.
Okay.
That trial setting will be is something that we can be open to, but he is not, I mean.
I'm not his first attorney.
No, I know who he is.
That's not a good thing typically.
No. Yeah, but I need to do certain things before we send him down, because I'm not gonna deal with him.
Okay. And on our Thursday hearing,
I did hear back from Dr. Pan first thing this morning, Judge. She was able to speak
Yeah,
to
when she
Ms.
talked
Brown.
to the dad last night too. I finally got him to answer the phone, his daddy.
She's gonna have her report ready by Wednesday. I don't know for sure what, correct, by tomorrow. I don't know what it's going to be. I asked if she's available Thursday to appear in case the court had questions. She has a conflicting appointment in Austin, but would be available by Zoom if that's amenable to the court.
Yeah, I talked to her. We're not opposed. Well, I'm not opposed to that, but I can't say. I mean,
Right.
honestly.
No, I don't mind taking her by Zoom.
Okay, I'll let her know. And I told her it'd probably be first thing in the morning, depending on what's
Depending on
happening
where
with
we
trial.
are.
Yeah.
Yeah.
So,
Yeah. If we're doing it by Zoom, that should open things up.
I would hope so, yes.
Okay.
I will wait, Judge, for you if you want me to wait.
Yeah, please do. We won't take long. Yes.
Was this came back from Miss Robin?
I mean, we'll have to.
Yes.
It seems to be clean.
All right.
So I was hoping for a reset on her. I still need to confirm with the state for offers.
Okay, hold on. Do you have Robin?
Medina came back clean.
Yeah.
I know. It's a good day.
Allison.
That's the
There it is, Allison. Nice to have you in here today. What brings out the big dogs? Oh.
Short straw?
I'm sorry
Different
to
supervisor
hear
made the
that.
schedule.
What's that?
Different supervisor made the schedule.
Well, it's nice to have.
You know you missed me.
Okay, so Robin Medina, we're just gonna move that to a trial setting. Okay,
do we move it to a police setting, Judge?
it's on a police setting.
Oh. That I think it'll get resolved in the next setting either way, Judge.
Yeah.
That's just fine.
Typically, we don't keep a deferred offer open when it's on a jury trial setting unless there's a really compelling reason to do so. So she wants the.
Robin
deferred.
Medina, we're moving to a
Well,
trial
I think
setting.
we need to. We'll talk afterward. I think she'll take that for,
Okay, great. Thank you for letting me know.
Then you need to let me know in the next week or two, because depending on when it's set for jury trial, I'll be sending out motions and subpoenas.
we're not planning on taking this to trial. We're
Yes,
waiting-
but I can't wait.
I
behind
get that,
this.
dude, but we're waiting until today because she was testifying in the capital murder trial, so we didn't get like an actual offer. Until
No, I've given you the offer.
But that was like the offer before.
Yeah, it's not changing.
There's nothing
No.
for like now.
No, you're lucky I'm still offering a deferred after the shit she pulled in that case.
She was the star witness of the case.
That might be stretching Star
I
a
doubt it's
bit.
stretching.
All right,
But-
y'all.
All right, thanks, Josh.
I'm gonna talk to Katie about that.
Actually, we do. She does.
Medina. Okay. What do you have, Mr. Matias? Are those Matias's clients?
No.
Is your client? All right, come on up, sir.
Okay.
Ariel. Su apellido?
Flores Velázquez.
Oh, I just gave you.
Flores Velasquez.
Lourdes Velasquez, he was on the announcement docket, I believe, and then failed to appear.
We were set for trial?
Because we couldn't, no, the thing is, he was supposed to turn in a
Who's
good
this?
guy pack. Huh?
Who is this?
Flores Velasquez. He was supposed to turn in a good guy packet, but we kept having difficulties. The last time he says he left it at home.
Okay.
And so we kept it on track just because he wasn't bringing in the good guy packet. So I think it got to the announcement docket. He failed to appear. He also has a case pending, I believe, in Guadalupe County. So now there is a different, I believe a different offer has been conveyed to him. I'm asking that it be kept on the plea docket one last time.
No, only because we were set to move it to a trial setting in August 2024. His failure to appear does not result in a better timing for him. He's also been sitting in jail, and so I have to put it at the top of the list. We'll move this to a December setting, trial setting. Sir, your next setting will be a trial setting, okay? That means you should be prepared to go to trial. Make sure, Mr. Matias, that we have his clothing.
Thank
Okay.
you, Your Honor.
All right, you can step back. Who's next? What's his name? The other one there? Is Mr. Matias, is that your client?
Yes.
The other one? Do we still have our interpreter?
No.
Is the interpreter gone? Do you know, Becky?
I believe she went to another court. She was just
Okay,
for that open plea.
okay. All right, your name, sir?
Tu nombre es
¿Cuál es?
Luis Domínguez Lara.
Dominguez Lara.
He was bench warranted, Your Honor.
Okay,
He took two in Caldwell.
Oh, there's an offer on the table. Yes, okay. Thank you for reminding me.
okay, you have an offer?
He's got an offer, but he doesn't like the offer.
Okay, do you have discovery?
I have discovery. Move it to the plea docket.
Yes. Sir, we're gonna move this to the plea docket. That does not mean that you have to plead, but if there is not a resolution, the next setting would be a trial. So
La próxima audiencia con la corte, usted tiene que decidir o vamos a ver si podemos negociar un acuerdo para terminar con el caso o de informarle a la corte que vamos a ir a juicio. Es la última vez, el último chance que nosotros tenemos de tratar de resolver este caso sin
can we do it in
juicio.
December?
La próxima audiencia. Sunday.
Well, I also have to say.
All right, good. All of those, now you're bringing up,
These three are done, Judge. I'm getting this Brown two brought up.
okay, and then you'll have,
Edward Ramirez and he's in custody.
okay, let's get him up. Who do you have?
That's Andrew Garcia. I was
Yes.
just able to get a hold of him a moment ago. He is out. He's actually where he says he can't get here today. He's pretty far away from here. Actually, he's in Florida working. I know, working, which I don't know who Bondman is or anything like that, but asking if any way you could allow him to show up next week. He could be here, no problem. And it's unorthodox to ask. But,
I'll ask you.
Judge, are there any docket notes or anything about him having issues before? If this is his first time having an issue appearing, I don't have a problem.
Garcia, please.
First street pass, I think.
Was he here for arraignment?
drawing
No
a
issues?
short-
we did a waiver room, but he didn't tell me he was going out of work.
It's not.
But
First setting, he came to arraignment and then FTA today.
If it's the first time we have an issue, Judge, I'm not gonna
Okay,
throw a fit.
set in for December docket and he better be here.
thank you very much.
Bailiff, we won't do the increased bond on Andrew Garcia.
Thank you, everybody.
You want December 9th or the 10th?
So.
Yeah.
Looks like probation's jobs are wrapped up.
Okay.
Thank you so much.
Well, I have to take over into
Yeah,
so,
well, thank you for being here.
but we're down the hall if you need our.
Okay, is there anything, I don't know if
I'm
there's,
pretty sure it is.
do we have any more pleas coming?
Think so?
Okay. All right. Thank you for being here. Thank you. Appreciate y'all.
You did the docket entry, but sometimes.
On top of it.
Judge, can you look at page 5 on the document? Second one from the top. Like they hire that attorney, Jesus Hernandez should not be here today, but I don't think that the defendant is here.
Jesus Marine? Jesus Marine, can you call that 3 times, please?
I did let the attorney's office know that he needed to be here,
Okay,
or a warrant would be issued.
all right. Set it for that December docket. Make sure they're both here. We're resetting that one. Felicia Martinez. She has until tomorrow
Yeah.
at 9:30.
What's the
Marco,
bond?
we have, yes, ma'am.
So the bond conditions you talked about earlier. for these two
Fantastic.
people.
Thank you for being here. Thank you for taking care of it. Let's try to get Ms. Blunt some help.
Yes, no, yeah. You know exactly what you're talking about.
Offer was fine. He wanted to use it for, he says. It's
Thank you.
Thank you.
Go to the tournament arrangements to take care of my jury when they start showing up.
Okay.
I had Jesus Miranda was the last one, page 5, number 2. Did you set the bond?
I think we're just gonna put that one for December. He's not.
He had an order to employ, he signed an order to be here today. He
Okay.
told the defendant, the attorney, that his client had to be here, and they did not respond to the phone call.
Okay, let's discuss. Then Marco, we're gonna do, is Marco on his way up? Marco on his way up, do we know? But I'm just, do you know, Ms. Brown, is Marco on the way up?
They were still figuring mine out, that was about the video.
Okay. And what are we doing on yours? Do y'all have any agreements on any of these bond reductions?
No, you're on.
Or to be on the, right? Bond reduction hearings?
I believe they do.
I do too. If you can tell me a good reason. They don't.
But the rules of evidence don't apply to them, so.
All right, so we're doing Ron Hell with you?
Yes,
Did we do it or what happened on Romero Gonzalez? Edwin,
Romero Gonzalez is not here.
okay,
I think he is in ICE custody. Let me look.
okay, okay, that's good. And do we have any announcement on the Marmolejo case? Marmolejo for trial from Hindera, did they?
No, they didn't give an announcement. I told them that they needed to be here on December 2nd for client.
Okay,
Romero Gonzalez is in ICE custody, Your Honor.
thank you. And we take a plea on Torres Padron. So you know.
Yes, we did.
Got you plea paperwork coming on Dominguez Laura.
Oh, you're gonna accept? Oh, so we have another.
Be down.
Man, I tell you, my negotiating skills. And arms. So I guess I need to bring them. Well, I will.
Yeah.
And I'll calculate his credit.
Marcus, come on up. Marcus, please.
What? No.
Morning.
Good morning.
He's saying that they're very trial. Vicky said it's not gonna be trial. That's great. We're still gonna.
All right, we're here today on a plea setting for these cases. Is that correct? Yes, we're here on a plea setting. Do the parties have an agreement?
No, we do not, Your Honor.
Okay, we're gonna move it to a trial setting. We can do it December, we can do it after. Or I won't do it.
After, I don't have time in December. I don't have calendar availability.
Okay.
I did that on purpose.
Move to a trial setting, please. After in 2025. There will be another judge that will try your case at that time.
Where are you going?
Well,
I'm honestly curious. I wanted you to see this one through fruition.
yeah, well, you know, you have a big reason to do with why I won't be seeing it through.
Really?
But yeah, you went on the run for a long time.
I didn't go on the run. You said you would send, if I wasn't here by 9 a.m., that you would send somebody for me. And I sat at my house waiting for that ride.
Okay, that's classic.
Just check the record, and that's what was said. I live in Houston. It's a long way to drive. I had no way to get here. What's the difference between a DA and a raging alcoholic?
Uh-oh.
There's a difference.
Apparently there might not be. Well, one stops at the bar, the other one orders us drinks. Well,
Okay.
I'm waiting for a response from Allison.
She's all red in the face now.
All right.
It was good. It was good.
Yeah, good luck. Who's next?
Mr. Granados?
Mr. Granados. You look different.
He's in orange.
I know, why?
Suicidal.
I don't like hearing that. I want to see you do well. Have you been taking your meds?
Mhm.
All right, well, what? We were just coming in because I was going to get a status conference to just see what the status of your evaluation was. Do we have that evaluation?
We did not yet, Your Honor. I did speak with the evaluator while she was conducting the evaluation of Mr. Granados, and that is when he had his suicide attempt, was during that interview. She indicated that she should have her reports forthcoming. So I imagine by the next court.
Thank
The
you.
next two are on the way up. Judge. Lozano, number one, page one. He's supposedly in custody of ICE, but we don't have any kind of hold on him.
Alon's, okay.
We wanna
I don't want to do
issue a
anything.
warrant?
I don't want to do anything. with it.
Nothing?
I mean, do you need me to have a warrant for it?
Yes, Judge, because otherwise his case, we don't have a next setting for him. We don't.
Okay. Well, what's his bond? Alonso Martinez. I'm sorry,
I'm here.
5,000 cash surety.
Okay. Then we were moving people around, so I missed what you said. Jesus Murray,
Jesus,
okay, try number 2.
I just wanted to be here in December, but you want on Jesus Marine, you need something? Because they were told that he needed to be here.
Correct. And he
Do we
signed the
know
order
that-
to employ.
Does he have notice? He had
He
notice to be
signed
here.
the- Yes, he signed the order to employ.
What's his bond?
10,000.
Increased to 12,500 cash surety.
Yes, sir. And number 7, bottom, also dealing with ICE.
Do you need something on that one too?
Yes, Judge.
What's his bond, please? 7,500 cash surety.
Basically, if Rice release them, we have no holds, we have no way to get them back. That's why we do the warrant.
Okay.
That's the clock on the case.
Yes.
All right, so who is your client?
Will Ramirez.
All right, is he here?
He's in custody.
All right, are we getting him up next?
I assume they'd ask for him.
Okay, because that's the only thing we're left on are those two, right?
As far as I know.
Huh?
Yes, Ramirez and Rainhouse.
Ramirez and Ren Hill. So y'all students, come on up real quick.
Court calls CR 24-2814F, the state of Texas versus Edward Ramirez. Can council please make their announcements for the record?
Allison Boost for the state.
Sam Martinez for Mr. Edward Ramirez, Your Honor.
And are you the same Edward Ramirez who is charged with aggravated assault with a deadly weapon and 2 counts of aggravated robbery?
Yes.
Is that you? Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, you can put your arm down. We're here today for your motion to reduce bond pending trial. Counsel, it's your motion. You can begin.
Your Honor, I waive open. I'd like to call my witnesses.
All right, call your first witness.
Teresa Ramirez.
Come on up, ma'am. Sir, if you'd step back for me. Thank you. Come on up here, ma'am. You raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth? You're gonna have to speak up.
Yes.
Okay, tell me your name and please spell it for the record.
Teresa Ramirez, TheresaRamirez.
Counsel?
Ms. Ramirez, how are you related to Edward Ramirez?
I'm his wife.
How long have y'all been married?
33 years.
As far as where do you reside at?
107 Falcon, Kyle, Texas.
And that's here in Hayes County, is that correct?
Yes, yes.
How long have y'all lived at that residence?
Going on 11 years.
Now, as far as what do you do for income and for a living?
I work at a clinic, Austin Regional Clinic, that I've been with 25 years.
And how much do you approximately earn per year at that clinic?
I would say probably about 55,000
And that's a year, is
a
that
year,
correct?
yes.
Now, you know that there is a bond set at this particular point in time, is that correct?
Yes.
Do you have the funds right now to pay for that bond at this point?
No, sir.
Now, at that residence on Falcon Drive, who all lives there?
It's myself, my son, daughter-in-law, and grandchildren.
Okay.
And grandson?
Grandchildren,
Grandchildren. How many grandchildren?
4.
To Mr. Ramirez? Are they
Grandchildren, our grandchildren,
your
yes.
grandchildren?
And how many children does Mr. Ramirez have?
7.
Are those all your children too?
5 of them are mine, yes.
Okay. And then 2 of them are his separate.
Are his from the first marriage, are my, yes.
Now, as far as do some of those children live here in the Hayes County area?
Yes.
How many children live here in the Hayes County area?
All except 3.
Now, and he's pretty much lived here for how long in this Hayes County area?
I would say about 20 to 25 years that we've been in the Hayes County.
Prior to him being incarcerated, was he working?
No.
When was the last time Mr. Ramirez worked?
I'm really not sure at that time that this happened because we were separated.
Okay. And why were y'all separated at that time?
Because of the alcohol and drugs.
Has he had a problem with alcohol and drugs before in the
Yes.
past?
In the past, no, he's drank, but he's never had an issue with drugs, no.
So that's something more of a recent episode.
Yes.
Now, he does in his prior history have a DWI, is that correct?
Yes.
He also has a case from Louisiana, is that correct?
Yes.
Do you remember how long ago the case from Louisiana is?
Oh gosh, that's got to be about 15 years ago, maybe 18.
Okay.
Somewhere around, yes.
But that's what you recall, is that correct?
Yes, it's been, yes.
Did he do any extended period of time in prison or anything like that?
In prison, no.
No. Has he done some small time in jail, that type of thing?
Yes.
Can he reside with you? I know you said y'all were separated. Can he reside with you at the residence there?
Yes.
Have y'all gotten back on speaking terms since he's been incarcerated?
We have been, yes.
And he has lived there before with that family too, is that correct?
Oh, yes, we've all lived there. My grandbabies were all, yeah, they were all born there with us.
I passed with this.
State,
And ma'am, you mentioned Edward living with you consistently in Hayes County, but he's left the state before for considerable periods of time, either for work or when y'all were having issues. I believe at one point he went and stayed with his sister in New York. Is that
Right.
So he hasn't continuously been living in Hayes County. He's kind of come and gone.
Only since this has happened.
Okay. Well, prior to this happening, he went and stayed in New York for
Right,
about
that's
how
when we
long?
were.
Hold on, one at a time, please.
About how long was he in New York for?
About 3 or 4 months.
Okay, and that was prior to the incident that we're here for today, the
Yes.
shooting.
Hold on.
Yes.
And then there's been other times for work when he leaves for considerable periods of time, correct?
Well, he was working here in Austin.
Okay. There have been occasions, for example, during the Louisiana incident, I believe.
Oh, that he goes on,
Hold
yes.
Where he has left the county for work for significant periods.
Yes.
Okay. And he was not living with you at the time that this incident happened.
Correct.
But you were aware that he was dealing with a drug and an alcohol problem at that point.
Yes.
That's why you had asked him to leave your house.
Yes.
And you had made, I'm sure, a ton of efforts to try and get him to stop drinking and using.
We did, but we didn't go through actual like counseling or any kind of classes.
I'm guessing at the point where you're kicking him out, you were telling him it's either the drugs and alcohol or your family, right?
No, it wasn't like that.
No, how did you end up kicking him out of the house then?
It wasn't me kicking him out. He really wasn't in his right mind, so he stayed out and had no choice but to, okay, well then go ahead and stay where you're at.
Okay. I'm guessing you weren't going to allow him to be high or drunk
Oh,
around
no.
Around your grandkids.
Around any of us.
Okay. And safe to say, as much as you love Edward and as much as you try to help him, Edward kind of does what Edward wants to do, right?
No.
No?
No. Before this incident, Edward has always worked and provided and been home with us.
But if Edward decided he wanted to drink and do drugs and that meant staying away from your house, he's been able to make that choice, correct?
Well, yeah, he has made that choice.
And when he's decided he wanted to go rob a gas station and shoot an employee at that gas station, he was able to do that, right?
I don't know what happened.
Fair enough. I'll pass the witness.
Ma'am, when Mr. Ramirez went to New York City or New York State, was he with family there too?
Yes, it was to work.
Okay. And when you say he was with family, who was he with at that time?
With Tina, my sister-in-law, Tina Garcia.
And that would be his biological sister.
His sister.
Again, she kind of asked you about the drugs and alcohol. You're not going to allow drugs and alcohol in your home, is that correct?
No.
And you're not going to condone the behavior if he did get involved with that type of thing. You're not going to condone that, is that correct?
Correct.
I'll pass the witness.
Nothing further.
All right, you can step back, ma'am. Thank you very much. Counsel, call your next witness.
Tina Garcia.
Hello, ma'am. Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth. Please tell me your name and spell it for the court reporter.
Tina, Tina, last name Garcia, Garcia.
Counsel?
Ms. Garcia, how are you related to Edward Ramirez?
He's my older brother.
You were here present when the testimony of his wife was being given, is that correct?
Correct.
And is it correct that at one point, Edward Ramirez did go and reside with you in the past year there in New York State, is that correct?
Hold on. Yes, I didn't hear that. I said, yes, he was living with me. Thank you.
Remember, although he's asking the questions, you're talking to him, she's taking down everything we say, and she's hearing through this microphone.
Okay.
So turn here when you're giving. Yes, ma'am.
You're aware that there are two counts of the indictment that the bond is quite high, is that correct?
Correct.
And have you looked at your family's resources to try to come up with the money for that bond?
Yes.
Have y'all been able to come up with the money for the $200,000-$300,000 bonds?
No.
as far as the money that y'all do have, how much money do you think you could come up with?
I can come up with 6,000 to 7,000 for a bond.
So when I filed this motion to reduce, you think you could make the bond if it got reduced down to 25,000 or so for each count? Is that correct?
Yes.
As far as what do you do to support yourself?
I do private care and I'm a certified nursing assistant in New York.
And can you confirm that Edward Ramirez does have a lot of family here in the Hayes County area?
Yes.
And he does have children that still reside here in this area?
Yes.
And as far as, does he have a mother?
Yes.
And where does his mother reside?
She lives in Woodway. That's in Waco.
That's in Waco, Texas. So he also has somebody also here in Texas from this area. Is that correct?
Correct.
Okay. And you do love and try to support him. Is that correct?
Most definitely.
I'll pass the witness.
No questions.
Okay, you can step back, ma'am. Thank you very much.
Your Honor, was that we do rest.
Okay, state.
Your Honor, at this time, the state would offer what's been marked on a flash drive as States Exhibit 1 and 2. They are portions of surveillance footage of the offense at issue, as well as States Exhibit number 3, which is a certified copy of the criminal records from Louisiana, and States Exhibit number 4, which is a copy of the probable cause affidavits in this case.
Any objections? States Exhibit
No
1 through
objection.
4.
She's given me that, Your Honor, and she's given me that into discovery.
States Exhibit 1 through 4 are admitted for the purposes of this hearing.
And permission to publish States Exhibit 1 and 2.
You may.
And if the court glances over the PC affidavit, it'll give the court an idea of what we're going to see. And just for the sake of speeding things along, I think we can agree to stipulate that it is alleged that the defendant is the person in the hat with the tag still on it that's approaching the counter at this point.
No, I'm not, no opposition to that.
And Judge, I'll move us to a different view, which is States Exhibit number 2. And I'll try to jump us ahead a little bit to the same time period we were just at. That is going to be the defendant allegedly entering the business. And then the BLC will cooperate. And Judge, this will be the portion that we just watched from the other camera. The party in the hat is alleged to be the defendant. party in gray shirt is one of the two complainants. Does the court need to see it again? I know it happens very quickly. This is usually our good player.
The same thing we just saw?
Yes, Judge, it's just to go back to the shooting portion.
All right, I'm good. I saw what happened. I want to know why the shooting on count 3 is the one with the actual ag robbery and the bond is 7,500.
That was based on the indictment, Judge. It was changed. The original charge that was alleged was deadly conduct, I believe. So we upgraded the charge when we indicted it.
But it stayed at
I
7,500.
believe so.
So the current amounts are, as you have here in your motion, 300,000, 300,000, and 7,500.
That is correct, Your Honor.
Okay. So the deadly conduct was what was count 3, and that's where they put it at 7,500. Y'all put it at ag robbery, and it stayed the same.
I believe that's the case, yes.
Okay, all right, that makes sense. All right, anything else from the state?
No, Your Honor.
Argument?
Argument, Your Honor. I mean, obviously, we understand the offense is a serious offense, but we do think that the court can put restrictions on him that can keep the community safe. He can be put on an ankle monitor. He could be required to drug test. I don't know if this county does scram monitors or drug patches, those types of things. I think if he stays sober and clean, he has family here, he's willing to work, he's willing to do the things that he needs to do to show up. We're just requesting that the bond be placed at an amount that he can actually try to afford and make that bond. He has minimal criminal history. They showed the prior, I believe that's like 20 years ago, and it was pled down to a simple assault. I believe he has one other DWI, Your Honor, and I think that's the extent of his criminal history.
State.
Judge, in this case, you'll note that the original charge in the Louisiana case alleged that the defendant stabbed someone in the neck. While that was eventually reduced to a misdemeanor assault, I think the court has to consider the nature of that offense in combination with the extreme violence of this offense. What we watched in the video was someone attempting to rob a gas station with a gun, being unsuccessful, and then without any provocation whatsoever, attempting to shoot an employee of that gas station. When his gun did not operate correctly, he manipulates the slide in order to charge the weapon. He then shoots the victim unprovoked, continues out the door, turns back to shoot him a second time. If the victim had not received the immediate medical care that he did, I don't doubt that we would be here today on a capital murder charge, in which case the defendant would not be entitled to any bond. Unfortunately, the nature of the conduct and the offense have to be something that the court considers in order to ensure the safety of the community. In this particular case, given the extreme violence that we have here, I don't know of any conditions that we can put in place that would adequately ensure the safety of the community, given his history within our community. So for those reasons, I would ask the court to leave the bonds where they are.
Anything else? Sir?
No, other than, Your Honor, I mean, we just asked the court to reconsider. I mean, the bond and setting the bond is not supposed to be an instrument of oppression. And we just asked it be made a situation where he can try to make it and put reasonable restrictions. We are asking for reasonable restrictions on that.
Okay, we'll reduce the bonds in count 1 and count 2 to 150,000. In count 3, it will be increased to 150,000. He must have GPS paid for by the defendant. He will be on pretrial services, be on house arrest. He can only leave the house for medical, school, and church. He will be under the normal curfew, even if he's out for those 3 purposes. Is there anything else we need to take up?
I just want to confirm 150,000 on each count is what it would be.
150,000 on count 1, count 2, and count 3. The one that I have is the only one where there's an actual shooting of someone will be increased from 7,500 to 150. Okay.
Thank you.
All right. We'll set this for trial in December, the latest date that we have.
Judge, I will tell you, my wife has surgery on December 16th, and I'm already set for trial on December 9th in McLennan County.
Okay.
Just trying to be proactive as far as that.
December 2nd.
I can't guarantee that we'll be able to get everybody served in time, but we can make our best efforts, Judge.
I would also say, I know I've talked to her about this. The one victim is from Nepal, and they're going to have to get an interpreter that speaks Nepalese. I think that's how you say Nepalese. So I don't know how realistic that can be.
There are 2 witnesses that would require Nepalese interpreters.
Okay. What do y'all want?
Now, I can do it January 1st or whatever, the first date in January, Your Honor.
Okay. Set it for the first opportunity in January. You'll have a new judge for that. Good luck to you, sir.
Thank you. Thank you, Your Honor. May I be excused?
Yes, you may. Thank you for your patience today. Next. Do you need me for something?
So quick announcement.
Stand by that red jacket,
The what?
the red jacket for the case of. Okay.
Yes. Did I get it? Yes.
On the Dominguez Ladas case, we have a plea agreement for the 3 years. However, he's an undocumented alien, so I need to go to the DLP.
Let's come back on December on Dominguez Laura.
Yes, sir.
Becky?
And on Flores Velasquez. Oh,
Becky, Dominguez Laura.
We already did these resets.
yes, he has a trial setting.
Okay, just make sure you let her know that we need that interpreter. And then,
Oh, yes, I will get them. And the other case is Flores Velasquez. We do have a plea agreement on that one.
Quiet, please.
We do need a Spanish interpreter. He is a US citizen, but we don't have a Spanish interpreter. I just want to notify the court that we have a plea agreement on both of those cases.
great.
That's it.
Do we happen to have an interpreter coming in the next few days?
We have to check with Yolanda, she's got to follow the interpreter.
I mean, are they for time or for probation?
For time.
Okay, well, let's get them done then. Go ask Yolanda when she has the next interpreter coming.
Okay.
Come back and let us know. All right, come on up, ma'am. Yes.
Ramirez, do you want him to have a GPS before he gets out?
Yes. All right, name, please.
Keely Ringdale, Judge.
You have that one. Okay, Ruby, are you ready?
Yeah.
Court call CR 24-1876F, the state of Texas versus Michaela Rangel. Can council please make their announcements for the record?
Allison Booth for the state.
Anthony Mendoza for defense.
And are you the same Michaela Rangel who in CR 24-1876F is charged in count 1 with driving while intoxicated with child passenger and count 2 with possession of a controlled substance, methamphetamines?
Yes, Your Honor.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, you put your arm down. We're here on a motion to reduce bond. Do you have a copy of that motion for me, counsel?
Yes, Judge. I have order to.
Thank you.
Looking at the motion, Judge, it's 100, I forgot the exact amount, maybe 183 days. She's now at 203 days in custody.
Okay, and the bond on those, is it?
She has 2 bonds, Judge, 5,000 each, cash surety.
Very good. We're here on that motion then. Go right ahead, counsel.
Thank you, Judge. Judge, it's going to be argument. Don't intend to put Ms. Rangel on the stand.
Very good.
Judge, she's been in custody for 203 days, 2 charges.
Before you make argument, then state any evidence.
Yes, Your Honor, state would offer state's exhibit number 1, which is a copy of the offense report with personal identifying information redacted.
No objection, Judge.
State's exhibit 1 is admitted.
And for the sake of brevity, I would suggest that the court turn to page 17, which includes the arresting officer's initial observations and is probably the most substantial.
Yeah. Okay.
Judge, the main argument here is that she's been in custody for 203 days. We are still awaiting toxicology results. The results did come back negative for alcohol in her system that night. So we're still waiting on results on whether or not she had meth in her system. You just reviewed the report. She does admit to officers that night that she did consume it within a time period, but it's possible, Judge, that maybe it was out of her system by then or it wasn't affecting her as much as the police believed. And so we were waiting on the results before we consider any type of plea agreement or accepting any type of deal. And I think it's more prudent for Ms. Rangel to await those results outside of custody, either on pretrial services, to get help if the court believes she needs help. She has been in custody, so she's clean. I believe she will remain clean, especially if she's on pretrial services. She has living arrangements outside of jail, either with her uncle or her grandma. As far as concern for the children, Judge, she no longer has custody of the children. They're with her mom. The mom has adopted the children.
And Judge, I'm sorry, I'm going to object. There's been no actual evidence of any of this before the court.
Sustained. You can continue. Not on those subjects, though.
Yes, Judge. I'll return to the main issue, judges, are the toxicology results. We're waiting those results. They haven't been returned back, so we don't know whether or not that's going to confer positive for meth in their system. And so for that main reason, Judge, I'm asking that the bonds be reduced to a PR bond. She be released, put on pretrial services, have her submit the drug test, and ensure that she stays clean.
And Judge, I would just point out that this court has not heard any evidence regarding the defendant's inability to post the bonds or what her living conditions would be or anything along those lines. What's clear in the offense report is that the defendant was incredibly impaired. Her judgment was clearly insufficient to be operating a motor vehicle, let alone be in charge of a child while operating that motor vehicle. She posed danger to the citizens of Hayes County. In addition to that, regarding test results, we have gotten the forensic scientist results regarding the methamphetamine that was located on Ms. Rangel. What we're waiting on is just the outstanding blood results. And given the nature of this offense and the extreme conduct here, the state would be comfortable going forward, quite frankly, even without those toxicology results.
Any final word from the movement?
No, Judge, no, nothing further intense.
All right, the motion is denied. If she gets out, she will be assigned to pretrial services. There will be frequent random UAs. She must be showing efforts to find employment and other pretrial service conditions for someone on a DWI and or substance abuse issues. Anything else we need to take up?
That's been fence.
Nothing from the state.
All right.
Thank you,
Thank you,
Judge.
ma'am. Good luck. Yep. We're gonna come back on a plea setting in December
Okay, Judge.
on this one. All right. That does not, let me just tell you, that does not mean that you have to plea. But if there is not some sort of resolution, the next setting would be a trial setting. Understood? We're off the record, and take a break. Your next setting is going to be a plea setting. What I'm telling you is that does not mean that I'm forcing you to plea or that you have to plea. But if there's not some sort of resolution, maybe it's a plea, maybe it's a dismissal, maybe it's something else. I don't know what it could be. That the setting after that will be a trial setting.
Yes, sir.
All right. Thank you very much.
Are we done with the docket?
Yeah, I think we're done with the docket, right?
There will be,
Yes.
Yes. Okay.
there will be a Spanish interpreter tomorrow with Judge Ware.
Okay. I'd like to take those two since they're in custody. We're gonna close tomorrow morning, right? That's the plan. Okay. Let's set it for 11, please. Both of those
Let's
two.
find out about the interpreter. I'm not sure how long they were requested for.
Okay,
They might not have been requested for
that long.
that long.
Okay.
Did they say who the interpreter was, Mr. McKee?
No, I didn't ask. But I'll be here. Regardless.
Ruby, you need this on that one.
Yeah.
And did you get it on, did I hand it to you on the others?
Yes, I have them.
Yeah, I'll need that.
You're off today, Ashley.
Thank you.
Just so that you're aware, our victim is driving in from Austin. She was in Buda like 20 minutes ago, so she should be here soon.
Okay.
Just give you an update.
And we're gonna take a little break, so I gotta
Yeah,
give
I think then that we should be perfect on time.
Ruby some time.
See, Ruby, you get to eat lunch.
Did you just get Ruby?
I just did. Did you want to change?
Frequent random. And. Yeah, conditions of every child, that's fine.
Or do you want me to, I have another page. Do
No, it's fine.
you want me to add something or take away something?
What's that?
Should we take away something or add?
No, on her, I just want you to do whatever you would do with someone who's got substance abuse issues.
All right, so do you want to put, SAE to be completed?
What's that?
Substance abuse evaluation to be completed?
Yeah, be great.
Already. Get it for- I don't remember time.
Okay. The medical school and church, is there anything else that we allow?
Oh, but do you want to sign that one? And, then we'll sign it.
Who wants?
The defendant, he's gone.
Okay. Oh, Michaela.
I'm just gonna put. Judge, I'm not getting a response from the office. Can I just set it for 9?
Yeah.
That's what time they schedule the interpreter to be good for Judge Aware.
Yeah, I mean, do we want, okay, yeah.
And it's just one case.
He's not doing 2?
No.
What's happened to the other?
The other one, I need a Padilla opinion.
Okay, so we're coming back in December on that one.
Yeah.
Right.
No, yes, that's the December.
Okay.
All
All right, good job, everyone. Busy day. Students, come on up.
Set it for 9. Because I know the